We're still in the defense portion of his case, and I know there was an issue raised last week about, I'm assuming your next witness is going to be the psychiatrist, is that?
So I have a short witness prior to that, Judge. I have Agent Lowe for about 5 minutes. The psychiatrist is Dr. Rappa. She actually got caught in an accident on Southern and is going to, her ETA is parking at 9:05. So if the court does want to wait for Ms. Coakley, it might be a little easier to just go straight through.
I'm not going to wait. The only thing I wanted to address is my understanding from last week is that there was a motion that the state was making in regard to additional opinions.
I advise Ms. Coakley I will not be pursuing that opinion, but I don't want to speak on her behalf, so I'm happy to wait.
All right, so nothing for the court to decide?
I don't believe so, but I don't want to misrepresent what Ms. Coakley would like to do.
Ms. Black, are you prepared to respond? And if she's on her way, I can wait a few minutes. Yeah, why don't you check? It's not the biggest deal in the world. This has gone on a while as it is, so another minute's not going to make any difference. Ms. Coakley, I was just raising with Ms. Murad the state's motion, or at least I thought you indicated you were going to file a motion in regard to additional opinions that the defense was attempting to introduce via Dr. Rappa's testimony. Ms. Murad has indicated that she's not pursuing that anymore, so I just need to confirm that there's nothing for the court to decide in regard to that. Is that accurate? Okay. All right. Good enough then. All right. So you want to call your next witness, and then we'll see. All right, and so just for planning purposes, give me a little bit of idea of what we're looking at today. I'm assuming this witness up front, Dr. Rappa, and then do you have any other witnesses besides the possibility of your client testifying this?
The defense has no other witnesses other than the possibility of our client. I do have video evidence that I would like to show.
Okay.
It is lengthy. It's a 14-hour video.
It's been admitted into evidence already, or it's going to be part of it?
I provided it to the state, and I have a copy for them that I'll give them right now. And she may have objections. I don't intend on playing the entire amount, though. So my hope
14 hours? All right. Do you know how much you do intend to play?
About 3.
Okay. All right. Yeah, I only asked not to infringe at all upon your defense, but only to get an idea as to what we're looking at in terms of logistics.
I watched enough videos, so I'm trying to be a little mindful about how I present it. But
It's going to be same type video that we've seen already? Okay. Okay. All right.
Yeah,
okay.
There may be objections, Your Honor. I was provided a list of what they intended to offer about probably 9:30 last night. Earlier, I was provided a list with 3,000 videos that was approximately 50 hours long. I started to go through that, but now it's my understanding that's no longer what they intend. And so I haven't had a chance to look at what they offer. That larger list did have things that the state would object to. Okay. So just to let Your Honor know, I haven't had a chance to look at this 14-hour video that they now have indicated they're going to enter.
So I'll address that when and if you raise it. So it sounds to me like, Ms. Murad, a reasonable shot of you resting today? Is that, all right. And are you going to make the decision as to whether your client's going to testify before or after you publish the videos?
I don't have an answer to that, but I suspect we will know a little bit more during the lunch hour.
Okay.
And depending on the court's rulings, that'll sort of
Okay.
determine as well.
All right, good enough then. All right, I think we've addressed all the trial issues that I needed to address this morning. Anything else we need to address before we bring the jurors in? Use the mic, Mr.
When do you want to have a discussion about jury instructions?
Sooner than later. We'll probably try to do it during the first break. Not the first break, but when we break for lunch, we'll spend a few minutes on that. Are there some issues on the jury instructions that I'm going to need to work through? You need to have a microphone.
So for the parental defense, it's our position that that the burden of persuasion, that once we present it, just like a self-defense, it is upon the state's burden to unprove it or to disprove, and just like self-defense.
Is there a standard that addresses that? Because I really don't intend to depart from the standard if there's a standard.
Yeah. So the jury instruction actually.
Well, here's what we're going to do. I just wanted to know if there's an issue. I will address it then when I bring up the instructions for consideration. We'll probably do that at the lunch hour and take whatever time is necessary to do it then. But and then just be prepared to tell me if there's a standard instruction at that time, and then I'll hear argument on everything. All right. So, Ms. Murad, are you ready to call your next witness in? All right, you may do so. Let's go ahead and bring the jury out now. All rise.
Jury in the room.
All right, everyone may be seated. All right, ladies and gentlemen of the jury, welcome back. I hope everyone had a good restful relaxation for the long holiday. I hope it was a long holiday for all of you. It was for the court. So with that being said, we are still in the defense portion of the case at this point. And with that, Ms. Murad, are you ready to call your first witness?
Yes, Your Honor. The defense calls Agent Chris Lowe.
Okay.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
All right, Ms. Murad, you may begin at your convenience.
Thank you, Your Honor. Good morning, Agent Lowe. I know you've been here before, so I don't want to belabor your background, but could you restate your name for the record, please?
Yes, I am Christopher Lowe with Jupiter Police Department.
And in this particular case, you received a Dropbox link of the Ring camera videos from Ring. Is that correct?
That's correct.
I just wanted to clarify a few things for the jury regarding that Ring camera.
Yes.
So it's my understanding that some of the videos from the living room are missing. Is that correct?
I cannot confirm that there's any missing videos.
Okay. We don't have any videos after January 9th of videos from the living room, correct?
Within the folder, I'm going to notate the
Go
folder
ahead.
name. Folder 24738902, which is a depiction of the living room. The files encompass January 5th through January 9th.
Okay. And of course, the jury has seen videos from January 5th all the way to January 28th. So it's fair to say that from January 10th to January 28th, there are no videos from the living room, correct?
As provided by Ring, correct.
Have you had an opportunity to view at least one of those cameras from the Ring camera that was placed in the living room?
Yes.
Okay. So when you look out into that camera, you see the living room in front, correct?
Correct.
It's kind of like behind a TV, it seems.
It's in a corner.
Okay. So in front of it is like a sofa, is that fair to say?
Yes.
And then the kitchen is behind it, correct?
Yes.
And then sort of off to the right, you see the dining room table.
Okay. I can agree to the sofa, the kitchen.
Okay. And do you recall if you can also see the dining room table from that angle?
I don't recall that portion.
Okay. Is it fair to say that no other Ring camera angle shows you the living room, kitchen, and dining room table other than that one?
Of what I observed, that's correct.
I also want to talk about, because the state played a lengthy video with the epoch time and UTC time, could you explain again to this jury? So my understanding is that the file names provided in that Dropbox are, for the most part, a series of numbers. Is that right?
That's correct.
And those series of numbers are indicative of something called epoch time.
Yes.
And could you explain to the jury again how you get from that file name to the date and time?
All right. So in regards to the Unix epoch time that I had previously spoken about, that number itself is a unit of time starting from January 1st, 1970, and it can be notated in seconds or milliseconds. And you can take that number, place it into just a simple converter online, and it'll produce the UTC time, which you can then convert to the Eastern Standard Time.
Understood. So the video that the jury saw, there was a montage of sort of a number of videos from inside of Ronan's room, those are in UTC time. What is the difference between UTC time and Eastern time?
So for the time in which we're concerned, being in January, it would be a difference of 5 hours for Eastern Standard Time.
So if something is, let's say, 4:35 p.m. UTC, what is it in Eastern time?
It would be 11:30.
So if Ronan's getting into bed at 4:30 UTC time, that's actually 5 hours later. Or I'm sorry, 5 hours earlier.
Earlier, yes.
Okay, I'm sorry. So the Eastern time is earlier.
Yes.
Okay, understood. So the bed example was not a great one. Prior to this, did I give you an example of a file number in this case to convert into UTC time and Eastern time?
Yes.
Okay. And was that file number 164-138-414-4000?
Yes, that's correct.
So how do we get from that to the UTC time and then to the Eastern?
So simply placing that number into the converter, as I mentioned, it produced a UTC time of 12:02 and 24 seconds PM. And then you just subtract you subtract 5 hours to get to 7:02 and 24 seconds.
Are there also file numbers that are not in epoch time?
Yes.
And those file numbers, I believe, start with like 70505?
Generally, yes, that's correct.
What unit of measurement are they in?
That's unknown to me.
Okay. And are those file numbers also indicative of a time and date?
Are those file numbers? Not that I know of.
Okay. Is there a process by which you can determine the time and date from those file numbers?
Yes.
What is that process?
So, as I previously mentioned, there are 11 subfolders within that return from Ring, okay? Within 6 of those subfolders, there's an individual file in each one. When that file is converted into an Excel format, it produces a timestamp associated with the files that begin in the 705. So a simple conversion into an Excel file provides the timestamps necessary to associate.
Thank you. All the videos that you were provided from Ring in that Dropbox are, for the most part, I know there's some that aren't, in 60-second intervals, correct?
For the most part.
And it's fair to say that there's no video of sort of 24-hour monitoring of what's going on in the home. It's just sort of those 60-second spurts that we all have to piece together when there's movement.
Correct.
Do you know why from January 10th to January 28th there are no videos of that living room Ring camera?
I do not.
Okay. And are you just relying on what Ring provided to you?
That's correct.
But it is fair to say that the living room camera prior to that did exist, right?
Correct, from what I received January 5th to the 9th.
And there's no video on the 9th, 8th, 7th, 6th of the Ferriters taking that down that you're aware of?
I did not review that camera in that specificity. I didn't review each of those videos, no.
Understood.
Yeah.
No further questions for this
All
witness.
right, any cross, Ms. Coakley?
You don't know why there isn't additional videos, right?
Correct.
They could have turned off the camera, right?
There could be a number of reasons, correct.
Then that's one of them, right? They could have turned it off, correct?
Correct?
They could have unplugged it.
That's possible.
Yeah. They could have, it could have just broken, correct?
Yes?
That's all the questions I have.
All right, any redirect?
Since it's movement activated, if they did come in and turn off the camera or take it out, you would suspect to see movement there, right?
Objection as a speculation.
Overruled.
That's possible to capture that video.
Okay. And in this particular case, Ms. Coakley gave you a number of options of it could have been this, it could have been that. It's fair to say you have no idea. You just have what you have from Ring.
Correct.
So you have no ability to say that the Ferriters turned that off, correct?
Correct.
And in fact, they didn't turn off any of the video in their son's own room, right, during that time period. There's no evidence of that.
I cannot determine whether or not a camera is turned off.
Okay, thank you.
Thank you, Ms. Murad. Is this witness now excused?
Yes, Your Honor.
All right, sir, that concludes your testimony, and you're excused from further proceedings in this matter. Thank you.
Thank you.
All right, Ms. Murad, call your next witness, please.
Dr. Sheila Rappa, she should be outside there.
And you're doing the direct, Ms. Murad?
Yes, I am.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Okay.
All right, Ms. Murad, you may begin at your convenience.
Thank you, Judge. Good morning.
Good morning.
Could you introduce yourself to us, please?
Sure, my name is Sheila Rappa.
Dr. Rappa, what do you do for work?
I'm a clinical and forensic psychologist.
I want to start with your sort of experience. Can you take us through your educational experience to become a clinical and forensic psychologist?
Yes, so I received a bachelor's degree in psychology in the year 1990. I went on to get my master's at Obizu University in 1994, and then I completed my doctorate in 1999, also at Obizu University. I did my internship at Miami Children's Hospital. I did the inpatient and the outpatient unit. And I did my residency at Atlantic Shores Hospital. I was licensed in Florida at the year 2000.
When you talk about some of your sort of work experience, can you take us through specifically the experience that you've had working with children with severe sort of behavioral issues?
Sure. My first introduction to children with severe trauma or severe behavioral issues was right after I got my master's degree. I had to do clinical hours, and I did them at a place called Kids in Distress that is in Fort Lauderdale. At Kids in Distress, it's a not-for-profit, but they take in all types of children, normally children that have been removed from their homes due to severe neglect or any kind of childhood trauma. So Kids in Distress would have any children from birth, all the way up. The ones I worked with were probably up to the age of 13 at that time. So I did that for my clinical hours, and then they hired me, so I started working there, and I worked a lot with children at that facility that were just severely traumatized, had diagnosis of reactive attachment disorder, had diagnoses of PTSD, just different types of childhood disorders. When I did my internship, or when I chose what internship I wanted to do, I really did want to focus on children, and I wanted to focus on victims. So Miami Children's Hospital was available to me, and that's one of the places that I applied to do my internship and was accepted. Miami Children's Hospital at that time had an outpatient unit, and they also had a locked residential unit. So I not only saw the children that were on the outpatient unit and did therapy with family and children, a lot of trauma. Also, there were the children that were on the inpatient unit that were actually locked inside the psychiatric facility because they were a harm to themselves or others. After I finished my internship, I quickly, within probably a year, started working at Chrysalis Health. Chrysalis Health is a community mental health center, serves about 3,000 clients a week, so very busy mental health center. Best known in the community for working with trauma and children and adolescents that are exhibiting behavioral problems, PTSD, any type of diagnosis pretty much that you can imagine. When I started at Chrysalis, I started just doing therapy, doing assessments. And then as I continued to work at Chrysalis, I became the clinical director. And right before I left Chrysalis, within like 3 or 4 years, I was their chief clinical officer. That meant I had to oversee probably 200, maybe 250 therapists that were doing the work in the families, in the homes, with the children, with the traumatized individuals. I also had to do the clinical programming for our group homes. We had residential homes, which were group homes, for adolescents that had kind of failed out of the foster care system. Nobody would take them, so they put them into our group homes. Severe behavioral disturbances, a lot of trauma there. And I oversaw all their clinical work for that. And then pretty much after that, I just continued with my private practice. I started a private practice quickly after I got licensed. And, worked at Chrysalis, also did a little bit in my private practice, but eventually the private practice kind of took over, and now I'm in private practice full time, and I only do forensic work. No more clinical work for me.
How long in your career did you do clinical work? So when did you go full-time into the forensic?
I did clinical work from 1995, probably until 2010, maybe?
So pretty recent.
Yeah.
That was your consistent practice, was doing clinical work. Is that fair to say?
It was. I really, really love the clinical work. I like being in the gutter kind of with the families and helping them figure things out and with children. My practice just got too busy and I couldn't do clinical work. I couldn't maintain the consistency anymore.
What experience do you have working with parents of children who have sort of early life trauma and severe behavioral issues?
Most of the parents that I have worked with that if you're going to talk about really significant trauma or really significant abuse, the parents that I would most likely work with would be foster parents or adoptive parents. There's not a whole lot of biological parents that I had to work with where their children were very severely abused or neglected, although there have been some. But most of it is foster care people that get their foster care parents that get these children and don't know what to do, or adoptive parents that get these children and they really just don't know what to do.
Now, your doctorate is a PsyD, so you're a psychologist, correct?
Correct.
This jury heard from the state's expert, Wade Myers, who is a psychiatrist. Can you explain to us the difference between psychology and psychiatry?
Sure. So psychiatrists are medical doctors. They actually go to medical school, just like your PCP would have gone to. They go to medical school. And then after medical school, they decide that they're going to specialize in psychiatry, and so they do rotations and get training specifically in psychiatry. Psychiatrists are probably best known for giving medication. So they do a lot of medication management. They know what types of medication to give for what type of psychological disorder. And really, some psychiatrists do some therapy, but most psychiatrists really deal with medication and medication management. Psychologists are a PhD. Mine is a PsyD because I'm a doctor of psychology, but it's easier to understand as a PhD. So it's a doctorate that you earn, and you have to have your bachelor's in some sort of human behavior study. Then you would get your master's in psychology and then your doctorate in psychology. So you're studying human behavior throughout, and really if you include your internship and your residency, getting your doctorate takes about 12 years. It took me about 12 years.
As a psychologist, assuming that you actually evaluate a patient, are you able to come to a diagnosis in the same way that a psychiatrist is?
We do the same things, except the psychologists will do psychological testing. Normally, psychiatrists do not do psychological testing. They might do screeners to kind of assess and see where they're at in terms of diagnosis. But psychologists do psychological testing. Other than that, pretty much we arrive to a diagnosis the same way.
In general, and we'll talk more specifically briefly, but sort of in general, what is psychological testing?
Psychological testing can encompass many different things. It can be educational testing. We want to see someone's IQ. We want to see their achievement, how they're doing in school. It can also be leaned toward figuring out if someone has a psychological disorder. Does somebody have depression or anxiety? Are they bipolar? Are they schizophrenic? Testing will help with that. It can also tell us personality makeup. How does this person function in the world around other people and function in general? So it really depends on your referral question, what types of testing that you're going to be doing, but there's a plethora of tests that we can give for all different types of things.
Those tests that you give, are they standardized and accepted in the community as being able to render, I guess, data that helps you determine those different things that you were talking about, like IQ? So if you're giving a test and some other psychologist is giving a test for the same thing, is it going to be the same test?
Yes.
Okay.
So the tests are standardized. The tests also have validity scales to make sure that you're not only giving the test reliably in the right way, but the test taker is taking them in a valid way. So these tests are more objective measures. It's not just somebody sitting back and looking at a case and then giving a diagnosis, but the testing really helps solidify that diagnosis.
I want to turn our attention to this specific case now. So you were hired by my law firm in this case, is that correct?
Yes.
And you're being paid for your time at an hourly rate, is that
Yes,
correct?
that's correct.
Is that common in your field?
Yes.
Okay. Are experts normally reviewing materials and coming to court for free?
No.
Okay. I want to go through what you reviewed in this case. Can you take the jury through that?
Sure, I can. I had to make a list because there's a lot. All right, so here are the records that I reviewed in this case. I had his early childhood records. I had photos of him as a child, and he had scabies on his body.
Sustained. I've seen your objection as she's testifying from the page in front of her.
No, it'd be her.
Yep. All right, Ms. Murad, you may proceed.
Thank you. Dr. Rappa, you can continue listing those items off.
Okay, the Department of State medical records, records from the Family Care International Clinic, and records from a Vietnam doctor. I had records from Family Counseling Associates, from Kathleen Martin, from 2015 and 2016. I had records from Dr. Rickenbacker from 2019, medical records from other providers 2019 to 2013. Then I had more from 2014, 2017, and more from 2021. I had school records from Immaculate Heart Academy, and there were emails in there between the Ferriters and the school staff. I also had his school records from Basis Academy, and again, emails between the Ferriters and school staff. An April 2022 clinical summary by Kenny Miller, who diagnosed him with reactive attachment disorder. I also had his non-psychiatric medical records from 2009, 2021. I had a memorandum. It was created either by the mom or the dad, I'm not sure who, detailing the efforts that they took to get Ronin help from 2012 all the way up to 2022. I had a photo of a fractured shoulder from...
Sustained. You can state what you received or reviewed, ma'am, but you can't go into the details of what that document was.
Okay.
Now, you may continue.
A neuropsych testing. I had an incident report from Devereaux Behavioral Health from 2022. I had Baker Act records from JFK and Central Behavioral Health in spring and summer of 2022. Emails between former foster parents and ChildNet. Interview transcripts of Alan Anderson, Kellen McCoy, and Steve Johnson. I had the CPT interviews I had both the videos and the transcripts. I had no deposition in this case, also the transcript and the video. Deposition in this case, the transcript and the video. Interview with Detective Sharp, the transcript and the video. Documents produced by a state expert. And I also watched several hours of Ring video, both the Ring video inside the room and outside the room in the home. I had the same packet that was sent to the state expert, Dr. Myers, and I had the deposition and trial testimony of Dr. Myers and the trial testimony of.
Thank you very much. So I want to talk about also what you could not review. Were you able to evaluate in this case?
No.
And was a request made for that?
Yes.
Sustained. Jury is instructed to disregard the last answer in question. You may continue, Ms. Moran.
Understood. It's fair to say that you were not, well, I will let that go. So you had an opportunity to review Wade Myers' trial testimony, correct?
Yes.
So I want to sort of start with your opinions regarding the Ferriter's actions. So do you have an opinion as to whether the Ferriter's actions were therapeutically correct?
Yes.
What's that opinion?
I think the Ferriter's actions were against anything that we would ever tell someone to do therapeutically.
Is it fair to say that the way the Ferriters handled this situation probably exacerbated these behavioral issues?
Yes.
But were those behaviors that had caused by the Ferriters, in your opinion?
No, I don't believe so.
I'll get into the specifics of that in a minute. Does the fact that Tim Ferriter handled the situation as inappropriately as he did, does that change any of the opinions that you've come to in this case?
No.
Why not?
Well, I mean, I think that what we see is a child early on that had a lot of difficulty with internal controls. Most children by the age of 5, if you want to kind of push it to 6, have already learned how to control themselves. They can control their behaviors. They don't tantrum. They can control, you know, if they feel like they want to do something, they can control impulses. But I did see through the records that this was a child that had no internal controls. And lots of times when a parent has a child that has no internal controls, they do try to put external controls around that child. This, of course, was beyond the pale. But those external controls are not something that is an unusual thing for a parent to do if they feel like the child is a danger to themselves, others, or is doing something so impulsively, and they need to keep an eye on them.
Okay. I want for the jury to establish sort of the timeline that I think is relevant in this case. So I'm going to state his testimony and let me know if it's correct. And this is the testimony from the trial that you reviewed.
Objection. Improper.
Approach. right, the objection is sustained. Ms. Murad, you can rephrase the question. Thank you.
So I want to go through some of the underlying facts that you relied on in coming to your opinion, okay?
Yes.
And specifically about when locks were placed on the store, okay? So is it your understanding, or were you assuming this when coming to your opinion, that this was born on February 28th of 2019?
Yes.
And that a room in the garage in Arizona was made about a week prior to that?
Yes.
And that a lock was placed on a room inside the home in Arizona that we lived in while Tracy was pregnant?
Yes.
Given that it was born in late February, is it fair to say that that has to be between about May 2018 and February 2019 at some point?
Yes.
Okay. I want to start by talking about some of the facts that Wade Myers relied on in his testimony. You already stated that you reviewed his trial testimony and his deposition, correct?
Yes.
Wade Myers testified that he did not have any substantial behavioral issues before the age of 8 or 9. Without getting into any specifics, is that a true fact based on your review of the records?
Objection.
Sustained.
Judge, can we approach on this?
You can. All right, the objection is sustained without prejudice, Ms. Murad, for you to rephrase.
Without getting into specific acts, have you reviewed evidence that shows that there were, in fact, behavioral issues prior?
Object. Is motion eliminated?
I'm sorry, I need you to approach again. All right, Ms. Murad, you may continue.
Thank you. Did you rely on records that showed and had behavioral issues prior to the age of 8 and 9 in coming to your various opinions in this case?
Yes.
Did you also rely on records that showed them did in fact have school suspensions?
Yes.
Would you characterize the time that was spent in his room, would you characterize that as him having experienced solitary confinement for 3 consecutive years?
Not really in terms of, you think about 3 full years of somebody being in solitary confinement where they're having no stimulation, they're not getting out of their room, nothing is going on like that. So no, I saw videos where he was out of the room, where he was eating with the family, where he was in the cul-de-sac or playing with the dog out back. One, he was helping them clean up the yard. One, he was helping them all move in the house. One, he and Tim were sitting at a table having lunch together. Videos where he's watching football with the family. So no, I didn't see it as, he was locked in a room at the minute he gets home and then he's never let out of that room until school time.
Were those videos that you reviewed Ring camera videos from the time period in Jupiter?
Yes.
Did you also review videos of him participating in meals with the family?
Yes.
Is there any evidence in the record that was only provided leftovers to eat?
Objection.
Sustained.
Did you rely on any evidence in the record that showed that it was only given leftovers to eat?
Overruled as to that question. You can answer, ma'am.
No, I did not see in records where he was only given leftovers to eat.
Okay. Okay, I want to get into your sort of specific opinions at this point. Do you have an opinion as to whether or not it has a lack of inhibition and emotional regulation?
Yes.
What is your opinion as to that issue?
I believe that struggles and has clinically significant signs of lack of inhibition and emotional regulation.
What did you rely on in coming to that opinion?
Well, there were a number of things, but one thing in particular is he had a neuropsych done in 2022. And so that report was very helpful to me in determining how his brain was functioning.
You said neuropsych. What is that?
Neuropsychological testing is a psychologist that focuses on that focuses on the brain, and the testing then shows skills and abilities that the brain is able to do.
Is neuropsychological testing something that you routinely review in your practice?
Yes.
And is that both your clinical and forensic practice?
Yes.
Do you personally administer some neuropsychological tests or the tests that were administered in this case?
Sure. The vast majority of tests that were administered in that case that the neuropsychologist did, I give.
Okay. So can you take us through what the different parts of a neuropsychological test are? And I have it in front of me, should you require your recollection to be refreshed. Would that help?
I think I have it too.
Okay.
So a neuropsychological is very similar to a psychological evaluation. The difference is that they focus more on brain functioning. So they're looking at, how what are their skills, their abilities, and how their brain is functioning. In this particular case, the doctor did get background information. I believe he spoke with mom. He also had records that he reviewed. He gave neuropsych testing. He gave quite a bit of neuropsych testing, scored that testing, and then he did what we call a mental status exam, meaning you have the patient in front of you and you're actually asking them questions, seeing how they reason, seeing if they are logical and relevant, watching their behavior, watching their mood and their affect, and you're trying to determine, where they are at that moment in time in terms of their psychological stability. So he also had that as part of his evaluation. And then he wrote up a report telling all the information that he got from the testing, from the interviews, from everything.
You stated that the neuropsychological testing includes information from mom. Is there, how do you determine if that's biased or not?
Well, you're going to have to get information from caretakers. That's just part of what we have to do to get full information. You can absolutely look at the information that you're given, and you can see, do records back that up? Is there anything that backs up what I'm being told? When you're giving testing to a parent or a child, that testing has validity scales. So you can tell through that testing if a parent's totally very negative toward a child, overly positive, thinking their kids have, halo and wings. You can tell these things in the testing, so that kind of gives you an idea of if someone's being truthful or not. And the same with the patients, the same with the person that you're interviewing.
What did the validity testing in this neuropsychological evaluation reveal about Tracy Ferriter's responses regarding
Objection as to relevance.
Let me have your approach.
Based on your review of the neuropsychological testing, do you have any concerns about the validity of that testing?
No.
What in the neuropsychological testing has informed your opinion?
There were a couple of things that stood out to me. He did an IQ test. He did an achievement test. The doctor did an IQ test also did an achievement test for those things were pretty standard. He also gave him what is called the brief, which is a test that looks at executive functioning, meaning frontal lobe of the brain, pretty much. How is someone functioning in terms of their brain and their behaviors? That testing was interesting to me. On that test, scored within the clinically significant range. When we say clinically significant, meaning it's above what somebody would just normally be. So it's clinically significant, and it's something that is going to be kind of on our radar. So on the inhibit scale, he scored clinically elevated, meaning that it's very hard for him to be in control of himself, especially with peers in the classroom. He requires a lot of adult supervision. His self-monitor scale was also clinically elevated, meaning it's very hard for him to understand the effect that his behavior has on others. He doesn't really have any insight into how he presents to others and what he's doing to others with his behavior. He also had a clinically elevated score for emotional control, meaning when he is flooded with emotion, he can't moderate that. He is explosive with his emotion, whether it's rage or screaming or breaking things, whatever. It's very hard for him to manage emotions, and especially anger. And just his regular emotional regulation index was very high. And, you know, this is important to me and it informs my opinion because we see when children have been traumatized, and normally very early childhood trauma will create a child that has huge problems with inhibition, emotional control, and they are completely unaware that, you know, everything that's going on around them is because of them.
So you mentioned just now that this is about sort of what happens in early childhood. You also mentioned that these are tests of executive functioning. So let's start with this. When is executive functioning developed in a person?
Well, executive functioning is ongoing, right? So the brain is continuing to grow, and the brain might continue to grow into adulthood until the 20s or in the 30s in some case. So, so that's a dynamic process. When we see things like in this testing, normally we can relate it back to children in early childhood because it's early childhood where we learn to manage our emotions, to not act out, to kind of be aware of how we are and what our peers think about us. And so that's a pivotal point where that part of the brain can be damaged, and then we can start to see testing like this.
Is it your opinion that the results that had come from early childhood neglect?
I'm sorry, say that one more time?
Sure. The results that we're seeing on the neuropsychological test, is it your opinion that those resulted from early childhood neglect?
Yes, that is my opinion.
Why is that your opinion?
I feel like that the early childhood neglect that we see in him from, you know, being in a foreign orphanage and from the records that I reviewed from that orphanage show, not only did he have severe neglect and it was malnourished, they were feeding the children sugar water in one of the records, and there was a very high infant to caretaker ratio, so that caretakers can't take care of all these babies that are in the orphanage, so they didn't get their needs met. He also had scabies on his body that were not treated medically. So this is a child that was severely neglected. We have no idea what happened to him the first 7 months of life before he was put on the orphanage door. We have no idea the neglect or the abuse. But I think that when you see that type of neglect, there is definite brain reaction from that. There's no way that you can have a child that is being neglected, and really, if you think about being ignored or the scabies, like even medically neglected and abused, that would not have some kind of brain fallout because of that.
To state the obvious, is that prior to the Ferriters adopting him?
Yes.
When was this neuropsychological test conducted, if you have it on there?
I will look. October of 2022.
Is the fact that if it was after January 28th, 2022, change your opinion about the fact that this has to do with early childhood neglect for women?
No.
Why not?
I mean, I feel like if this testing had been done, you know, even 2 years before, we probably would have seen a very, very similar pattern. We probably would have even seen a similar pattern when he was younger, because we can tell through the records that this is impulse control, self-monitoring, emotional regulation. These were things he consistently had problems with across all settings.
Is there any evidence in the records that any of the physicians or psychiatrists or social workers that the Ferriters went to recommended a neuropsychological evaluation?
No, I never saw that recommendation.
I now want to talk about another opinion in this case. Do you have any opinions about whether or not it has symptoms that are indicative of an attachment disorder?
Yes.
What's your opinion?
I do believe that his symptoms are an indicative of an attachment disorder.
Why?
So first of all, I see reactive attachment disorder was diagnosed in the records for him, starting as early as I believe he was 7 or 8. I don't know that at 7 or 8 they had fully diagnosed it, but the therapist was telling the parents, hey, I think this is more than what I thought it was, and I think I think it might be reactive attachment disorder. And then it was more formally diagnosed by a psychiatrist a couple of years after that. So I not only see it in the records, but also in terms of the behaviors that we were seeing and through the records, point to a child that's having problems with attachment and pretty significant behaviors because of it.
So let me stop you there because I want to understand what an attachment disorder is. So what's attachment?
Well, attachment is the most fundamental, basic thing that children need in order to be successful in life, in order to make friends, have intimate partners, being good at their job. Being able to attach to people means that you have stability, you have empathy because you can understand what someone else is feeling, not just yourself. It also helps you establish trust so that you can have a relationship where you can be independent and someone can trust you and you can trust them that they're going to meet your needs if you need it. When children early on don't get that, there's a whole disruption that happens that affects every part of their life because we're social creatures, and if you're not able to trust people and navigate life socially, then there's a problem and it leads to what we call a disorder.
When is attachment developed in a person?
A lot of attachment issues have been looked at, of course, in my field, because it is such an important issue and a lot of things hinge on your ability to attach in a healthy way. Normally what we see is there's a cycle of attachment from the moment that child is born. So what we see in the cycle is a child that is born, and let's say that child is wet or soiled or hungry or cold. That child starts crying. Immediately an adult comes, a caretaker comes, picks up that child, takes care of that child, soothes that child. The child's then able to self-regulate, go back to sleep, or whatever they're doing. This cycle occurs thousands of times with parents. If you've ever had a newborn, you know it's constant. And if you're constantly going after that newborn every time they cry, soothing that newborn, helping that newborn then learns, I have someone I can trust, I have someone I can attach to, and I know that if I get out of control or I need something, there's an adult that's going to come along and that adult is going to help me. Children that do not get this, there's an interruption in that attachment. So you can imagine all the things. They don't trust that anyone will ever take care of them. They don't trust that their needs will be met. They can't see the world from anyone else's perspective. So attachment is a huge thing.
When we talk about attachment, I mean, what separates attachment disorder from a kid that's just like kind of awkward? Like, because it sounds like it's something that affects the personality, but is it just that you kind of end up being like uncomfortable or awkward, or are there other behaviors associated with having an attachment disorder?
When you have a disorder in general, so I'll talk in general first. When you have a disorder, a lot of people, you'll hear people say, oh my gosh, I've got bipolar, I'm so moody, or oh, that kid's got ADHD, he's so hyper. It's not just something that's at the level that we normally see in life. It's at a level that we think that it is clinically significant, and it's a disorder. It's disrupting their life. It's disrupting the lives of people around them. So just because the nature of the disorder means that this is something that's hugely problematic, and hugely problematic not just to the person that has it, but to the other people that are around that person. And in terms of attachment disorder in particular, what we normally see, so normally you'll get a child that has a reactive attachment disorder. They come out of a very bad environment. They go into a home that's loving and kind and has stability and structure. We normally see that the child begins to get better. So the attachment disorder gets better. There are children who have what we call persistent reactive attachment disorder, where the damage was so severe in childhood that as they get older, we don't necessarily see that damage start to go away. If they're plugged into the right therapies and they know the right places to go, and some of them, have to go to higher levels of care, then we might see some sort of healing, but it's something that they will struggle with, for some of these kids, for their life.
What behaviors are associated with reactive attachment disorder?
Objection. Relevance.
Overruled.
Go ahead. What behaviors are associated with reactive attachment disorder?
So when you look at, so when we diagnose, as psychologists, as psychiatrists, anyone in the mental health field, we have to use the Diagnostic and Statistical Manual. So this tells us what signs and symptoms to look for and how to diagnose. So if you're going to look up reactive attachment disorder in the DSM, you're going to just find pretty much a general way of looking at symptoms. So it will be that the child cannot be soothed by their caretaker. The caretaker tries, when the child is out of control, to soothe them, and the child wants none of it and continues to tantrum. Or the child doesn't go to that caretaker for the caretaker to take care of them. Most children, when they get hurt, run to their parent. No, these children do not. They kind of keep the parent away. So there's kind of a general way of describing reactive attachment disorder when you see it in your practice. However, when you start to look at when people are studying this issue, what you will see is that there are certain behaviors that are kind of indicative of a kid that has reactive attachment disorder. And it would include lying, frequent lying for no good reason, just lies that make no sense. It can be aggression, it can be violence, it can be being mean to animals, being mean to younger children, stealing, hoarding. Food is a big issue for children with reactive attachment disorder. So they gorge on food or they steal food. They're constantly food preoccupied. Some of them don't eat. So it really just depends on, how that is manifesting in each individual child. But it's a significant psychological disorder when you see the symptoms involved of children whose reactive attachment disorder did not get better just because they were put in a loving home.
What, in coming to your opinion that has behaviors indicative of attachment disorder, what are you relying on, or can you explain to us how you came to that opinion?
Yeah, so there's multiple records that talk about the behaviors that the family was seeing and dealing with in the home, from psychiatrists, from a treatment provider in 2015, all the way up. All the way up to now, we see these behaviors. So it was pretty well documented that the behaviors that were being seen were indicative of a reactive attachment disorder. The lying, the stealing, especially the food issues, just almost everything. Cruelty to animals or being mean to animals. I'm not going to say cruel like horrible, but being mean to animals, being mean to younger, more vulnerable children. These types of things we do see in his history.
And does that predate, let's say, about May of 2018?
The very first record I saw where the family was really describing the behaviors that they were dealing with was 2015. So I believe he was 7 or 8 at that time.
You talked a little bit about gorging being common for children with attachment disorder. Can you sort of take us through what happens and why that happens?
Well, I think it's easy to understand. If you are starving as an infant and nobody is feeding you, then your brain has learned that you can be hungry and you're not going to get taken care of. You're not going to get fed. So it becomes a preoccupation with food, a preoccupation on how do I get food, and when I do get food, I want to eat every single thing that I can eat immediately. Or I'm going to hoard food. I'm going to hide food in my room. I'm going to hide food in my backpack so that I'll always have food. It's really very sad because it really is from a brain that was so deprived of basic needs, and now even into childhood they're still struggling with that kind of stuff. And we see that with a lot of food-centric ideas and wanting to get a hold of food. And not having any kind of breaks on food when he does get a hold of something sweet, to the point of even stealing food.
Is that sort of gorging of food and hoarding of food, is that healthy for a child? Should a parent allow that to continue to happen?
No, you wouldn't allow a child to gorge on food.
Is there any indication in the record that the Ferriters were educated by a psychiatrist or a medical professional about how to handle this gorging issue in a meaningful way?
Objection, call for hearsay.
Sustain. You can rephrase, Ms. Moran.
Sure. Do you have any opinion, and we'll talk about this more in detail, as to whether the Ferriters acted with malice?
Do I have an opinion? Yes.
Okay, what's that opinion?
I do not think that they were maliciously trying to harm their child and make things worse.
I want to talk about that in more detail in a little bit, but as it relates to the food, why do you think that?
Well, I don't understand.
Sure. So I want to talk about your opinion regarding them not having malice in what they did, but as it relates to and how much he was permitted to eat, what is your opinion about that and the fact that they were not acting maliciously?
Oh, okay. So I think that not only in his deposition, but also in the deposition of his sister, they do talk about that the mother was very health conscious, that the mother didn't want the children having sugary snacks. They mentioned the snacks that she allowed them to have. And forgive me if I'm wrong, but it was stuff like granola and yogurt and bananas and things like that. The sister testified in her...
Sustained.
Without stating exactly what said, can you just talk more generally about your opinion?
Sure.
Thank you.
Sure. So I believe that the mother was trying very hard to make sure that didn't get too much sugar.
Sustained.
What is your in determining? So I guess not speaking about your beliefs, but what the records actually show. What efforts were made by the Ferriters that makes you believe that it was not malicious?
Objection as to your saying.
Overruled, but the witness is instructed not to relate what anyone said to you, just what you reviewed and what drives your opinion.
Go ahead.
According to the records, a pediatrician told mom not to give.
Sustained.
Do you have any belief, is it your opinion that the Ferriters were withholding food from him intentionally to harm him?
No.
Is it your opinion that it is related to the fact that he was hoarding food as a result of his earlier condition?
Objection calls for speculation.
Overruled as to that. You can answer, ma'am.
Go ahead.
Yes.
Okay. How are children with attachment perceived by adults who are not their parents?
Oh, that's a good question.
Can you restate that question again?
Sure. How are children with attachment perceived by adults who are not their parents?
Sustained.
Can we approach on this, Judge?
Can. You may continue, Ms. Murad. The objection is sustained.
Is reactive attachment disorder associated sometimes in children with a level of manipulation?
Objection. Relevance.
Approach. right, the objection is overruled with directions to counsel to rephrase the question.
With reactive attachment disorder, is manipulation by the child who is diagnosed, is that common?
Yes.
Okay, can you explain that to us?
Yes, so these are children that want control over their environments. They don't trust adults. They are, looking for ways not only to seek attention, but also to manipulate, to get their needs met. They feel like they have to manipulate to get their needs met, rather than being direct about it, because their needs were never met directly.
Is your opinion that also exhibited these behaviors that are indicative of reactive attachment disorder?
Yes.
Explain that to us without getting into anything prior to his age of about 9 or 10.
Okay. Are you asking me what in
What behaviors
general
did
been
exhibit?
before 9 and 10?
Oh, no, I'm
Rappa,
sorry.
Dr. Rappa, can you pull the mic a little closer to you?
sorry.
So you picked up better. All right, thank
got
you.
it.
No, I'm sorry. I'm asking you to talk about specific behaviors in the record that have led you to that opinion without getting into the specifics of anything prior to the age of 8 or 9. Sorry, 9 or 10.
Thank you for the clarification.
No problem.
Yes, so manipulation by Roman. He's a very interesting child. So at one point,
I'm going to sustain the objection. You can restate the question, and we'll hear the answer again.
Is there, and on what basis, Your Honor?
I'm sorry?
On what basis is it sustained?
Her opinion as to whether he's interesting or not is not relevant to the case.
Okay, without saying that he's interesting, could you explain what behaviors you reviewed in the record that are helping inform your opinion?
okay. So in the record, there were instances.
Overruled. You can state what you reviewed, ma'am, and how it informed your opinion, but you cannot go into detail about what specifically was said because that's hearsay. So you have to be able to answer the question posed by your attorney without disclosing specifically what was said by someone outside of this courtroom.
Okay.
Okay, thank you. Do you understand that instruction?
I think.
All right, well, we'll see if you can
See
follow
if I
it.
don't.
All right, thank you. Go ahead.
So what records did you review that indicated that?
School records, also records of when he would go to the doctor or saw the psychologist or psychiatrist.
Did you have an opportunity to review the video deposition of?
Yes.
And that was about 5 hours?
Yes.
Is there anything about the way in which it presents that also is indicative of attachment disorder?
I mean, I don't know that you would look at him and you would say that the way you present is, an attachment disorder. But the things that I noticed in the deposition or that were kind of flags for me as a psychologist, he is very kind of detached from what he talks about. He can talk about it in an intellectual way, but he doesn't necessarily talk about it in an emotional way. So he kind of gives you facts without necessarily having that emotional congruence with the facts. One of the things that is interesting to me is that during the deposition, he was pretty blunt affect. He doesn't have a whole lot of affect on his face, whether it's, joy or anger or anything, it's kind of blunted. However, during times where he would talk about things that he had done, such as giving beer to his younger brother, and to see the effects of alcohol on young children, he started giggling. Or he would laugh when he would talk about that he went into his sister's classroom.
Overruled. You can only say what his observations were and his response, but not what he said specifically. So overruled.
Go ahead, Dr. Rappa.
So he would laugh at inappropriate things that he had done. But other than that type of laughter, he was pretty blunted in terms of his affect.
Why? I think you called it congruence. What do you mean by congruence?
It's really important when we're communicating with people that we are congruent. So what we're feeling is what we're showing to that person. If you're feeling something and not necessarily showing it, then people can kind of pick up that you're incongruent, something is going on with you, and it leads to lack of trust. So it's important. Congruence is important. It's also important because it makes somebody predictable, so that if you say something to me and I know that you are someone who what you say is exactly what you feel, then I can trust you and I can predict your behavior towards me. When people are not congruent, you can't necessarily predict their behavior towards you, because what they're saying and what they're actually feeling are two different things. So the congruence is a huge issue in relationships.
Why is that concerning for children in particular? That lack of congruence.
A lack of congruence in children, one of the things that an adult role is to teach children to be congruent, to teach children what you're feeling is what you need to be speaking, in a respectful way, but you need to speak your feelings. If they don't have that, then the child is an unpredictable child, because the child can parrot back to you what they know you want to hear, but they're not necessarily changing anything internally.
What is the treatment for an attachment disorder? What are the treatments?
There are treatments for attachment disorder. There are also some treatments for attachment disorder that are very, off the cuff and not good treatments, and nobody really, and professionals would recommend them. But the treatment right now for attachment disorder, most people would treat it as a trauma-based disorder, and they would do trauma-focused cognitive behavioral therapy or regular cognitive behavioral therapy. There's dialectical therapy. There's certain therapies that are known to work with children that have attachment issues.
Were any of those ever recommended to the Ferriters?
Objection as to hearsay.
Sustained.
Is it your opinion that the Ferriters were, do you have an opinion as to whether the Ferriters acted with malice when it comes to the treatment of attachment disorder?
Yes.
Okay, what is that?
Mara, can you approach for a second? All right, so the court is reconsidering its prior ruling on the question of whether there were any recommended treatments. Ms. Murad, you can ask the witness that question with respect to her review of the records that she had presented to her in this matter. But, ma'am, just so you know, you're only able to answer that question with respect to the records you reviewed. You're not allowed to get into that with respect to anything else anybody else may have said to you, because that would be hearsay. But if there's something in the records that can form a basis for you to answer the question, I'll allow you to do that. Okay?
Thank you, Your Honor. Based on the records that you reviewed and coming to your various opinions in this case, is there any evidence that the Ferriters were recommended those treatments that you just mentioned?
No.
Is there any evidence in the records that you reviewed that they were recommended inpatient treatment for attachment disorder?
No.
Is there any evidence in the record that the Ferriters were recommended to go to a specialist for attachment disorders?
No.
And just so we're clear, Ms. Murad, you're talking about the records that she reviewed,
Yes.
not in the record in the global sense of this proceeding.
The records, just the ones you have. Yes. All right. I want to go into Your Honor, my nenext opinion does require me to approach. I'm wondering if it's a good time for a break.
Yeah, it is good because we've been going about an hour and a half this morning. So we'll take a break, 15-minute break. It's almost 10:30. We'll be in recess until 10:45. All right, everyone may be seated. All right, you need to approach?
Could we just do it?
We can do it
Here. So, Judge, my next opinion, the court has sort of made a preliminary ruling on this, but I wanted to readdress it before I asked Dr. Rappa. So, in the cross-examination, actually I think it was in the direct or redirect examination of Wade Myers opined that when you remove a child from the environment that they're in that's causing issues with their attachment. So specifically, and we listened to this yesterday, so Wade Myers agreed that he has probably an attachment disorder from his early childhood when he was adopted. He then said that it was, quote, brought back by the Ferriters. And he then said that if he is placed in a different situation or environment, or children with attachment issues are placed in a different situation or environment, you expect to see an improvement in their behavior. And so I believe, based on the records that Dr. Rappa has reviewed, that at the very least, the defense should be able to counter that position to show that that improvement has not in fact happened, because there is an issue here of the persistent reactive attachment disorder and how the Ferriters couldn't have really done anything to improve it. And it is direct rebuttal to what the state's own expert testified to. So I would like to get into that, and I'm sure the state will be objecting.
All right, so Ms. Coakley, make sure you use a mic and state what your position is.
Yeah, I mean, the state would object. I think that there is a fundamental difference between saying generally this is how it is addressed, which is what Dr. Rappa has already testified to, that generally how it's addressed is that it focuses on the parenting in a nurturing, safe parenting environment. There's a fundamental difference between that testimony and saying that that would have solved it in this case, which is not what his testimony was. He testified generally. Beyond that, it's much more complex and nuanced than the defense wants to make it seem. It's not an automatic solution. I don't think any psychiatrist or psychologist would say that, especially after 3 years of additional trauma perpetrated by the defendants, then to go into every single thing that has occurred to the child after.
So what is the legal basis of your objection? Is it foundation? Is it relevancy?
It's improper character evidence, Your Honor. And whether or not the child in this case was cured after being removed from the parents is not a relevant determination for the jury. That doesn't have any bearing on whether or not the defendants committed a criminal act in this case. Whether
that sounds like a relevancy objection to me as well.
Right. It's like nuance. So it's like the idea is first that it's improper character evidence that confuses the issues and is prejudicial because it gets into such a complicated issue. But so it's Your Honor in limine said that is not permissible. It's improper character evidence.
And that's right. And that's why Ms. Murad said I'd already preliminarily ruled on it.
But beyond that, it's not even relevant because like how easy or how hard it was to manage their child is not a defense to the criminal charge here. And so whether or not he was able to or continue to have behaviors after they were removed is not relevant to the determination of the defendant's intent or knowledge in this case, or whether or not they committed a criminal act of child abuse.
All right. Final remarks on it, Ms. Murad. And I'll help you out with at least the concern I have is I think it's completely irrelevant whether the child gets well or not after he's removed from the home, because I agree with the state's position that whether the child gets better or not does not decide the issue of whether the treatment and the conduct of the parents in dealing with the child prior to the child's removal was appropriate or not to the circumstances. You've testified as to the circumstances that, or you've had your witness testify as to the circumstances that existed while the child was at home, and that was with the reactive attachment disorder. So that's appropriate, but now, and that's relevant because that's what they're dealing with in real time, and it guides and determines their conduct, their response to a minor child having reactive attachment disorder. But what happens after the child's removed? I have a real difficult time connecting the dots because it's irrelevant to the parent's conduct that they pursued while the child was with them and while they were dealing with the issue. So that's my major concern, is it's just not relevant. And why should I change my pretrial ruling already made in this case that I wasn't going to allow this area of an opinion and conduct to be looked at?
So the reason I think the court should reconsider its ruling is because the state has made it relevant. Everything that the court is saying in the state's sort of argument in the second half of their argument is the same thing that we litigated in motions in limine. We are now in a different posture. The state could have instructed their expert, do not say anything that could create an issue with what's happened after the fact. We all do that with motion in limines, and we instruct our witnesses, don't testify like this, don't bring this up. Now it has become relevant. So the reason it's not improper character evidence, as the court knows, is only inadmissible to the extent that it goes to show propensity. That's not what we're doing here. They have had an expert, a doctor, testify that when you remove a child from that situation, they will get better. And he may have said that generally, but we're in a case here about his behavior and whether or not the Ferriters are guilty or not guilty. Now, I understand the state's position as to, these are perpetrated by the Ferriters. Their version of the theory of their case is not, I do not have to abide by that. I certainly understand that there are relevance objections and everything, but their version of their case they can present. I don't have to present that version.
Okay. I recall well the underpinnings of my ruling pre-trial on this, and I can tell you that my ruling was informed by much more than just a relevancy consideration, but it was also informed by significant case law that had been presented to me regarding the privacy interest of the victim in this case. And it was because of that and a substantial amount of authority that weighed in heavy favor of not allowing this type of information to be pursued with a victim in general, but a child victim in particular. So I'm going to sustain the state's objection, maintain my pretrial ruling and my order in limine on this. So with that, I'm going to give, do you need anything else? I'm going to give you a break until for you to continue.
Can I just proffer the questions?
You can proffer the question. That'll be fine. Go ahead, Ms. Moran.
Thank you. Wade Myers opined that when you remove a child from an abusive environment, you expect to see improvement in their behavior. In general, do you agree with that? We're just proffering, so you have to answer it. When would you not agree? Are there circumstances where that's not the case?
Sure. If the child has real significant psychiatric problems, then we're not going to necessarily see it remit just because they're put in a different placement.
In this particular case, is there evidence that has in fact improved since his removal from the Ferriter home?
I'm just going to object because
This is proffer.
I know it's proper, but we're in open court here. This information was protected pursuant to multiple privileges, and so now to put it on a televised.
I think that's a fair objection. Let me have both sides approach. All right, thank you, Mr.
And then when is our break until judge? I'm sorry.
42. All right, so the court is going to sustain the objection. It's without prejudice to the defense to do a written proffer with a confidential filing, because the court has found previously that the minor victim's treatment post removal from the home is protected information, and it would violate his privacy interest to have that disclosed publicly. So I'm maintaining that ruling, maintaining that protection that I originally ordered. However, I also acknowledge the defense's right to put on a proffer of what evidence it would have submitted but for my ruling, and I will allow that to be done in a way that it is not public at this point. You can do a sealed proffer for filing that will become part of the record going forward. Ms. Murad, anything else before we've chewed up the break, but I'm going to still give you 5 or 10 minutes. Anything from state? All right, so we're going to take a brief recess. Ma'am, you can step down, stretch your legs, but during the break, you're not to discuss your testimony with anyone. You understand all that? All right. Thank you. Court will be in recess for another 10 minutes. All right, everyone may be seated. Ms. Murad, you ready to continue?
I am, Your Honor. Thank you.
All right, Mark, you may bring the jurors back out. Yes, sir. Ms. Murad, I'm going to, instead of doing a written proffer, we're going to do a sidebar, and we'll do the proffer at sidebar when this witness is done.
Sure. No problem. Whatever the court prefers.
All rise.
Jury in.
All right, everyone may be seated. Ms. Murad, you may continue.
Thank you, Your Honor. Dr. Rappa, we talked about reactive attachment disorder. I now want to turn to something else that you mentioned during the course of your direct examination. Do you have an opinion as to whether one has symptoms indicative of oppositional defiant disorder?
Yes.
What is that?
Approach. All right, the objection is sustained. You may continue, Ms. Moran.
Do you have any opinion as to whether he has PTSD?
Yes.
What's your opinion?
I do believe he has signs and symptoms consistent with complex post-traumatic stress disorder.
What is complex? Well, let me start with this. What is your opinion as to when that complex PTSD started?
I believe that it started when he was an infant, when he was a very, very small child, up until the time he was around almost 2.
Explain that to us. How are you able to make that determination?
Well, post-traumatic stress disorder in infants is something that has recently been looked at. People thought, oh no, they're newborns or they're young children, they don't remember anything, and nothing in their environment really impacts them, so it doesn't matter. Nothing really can be further from the truth when you start to look at it, and when it is studied. So children that have had adverse childhood experiences, whether it's trauma or severe neglect or medical neglect, anything like that, can cause signs and symptoms of post-traumatic stress disorder in infancy.
So when you're determining whether or not a child has complex PTSD that's rooted in issues from infancy, are you relying on the DSM-5?
No, normally what you're going to rely on when you're diagnosing a young child is called a diagnostic classification 0 to 3. So it looks at young children, and then it looks at what behaviors young children might exhibit, as opposed to the DSM, which does talk about children with PTSD, but really doesn't deal with early life experiences.
Is it your opinion that the Ferriters caused the complex PTSD that one has?
No, I mean, I think that it's a complicated mix of reactive attachment disorder and complex PTSD due to everything that he went through from birth until like 17 months of age.
And without discussing the substance of the records or any hearsay, is there evidence prior to about May of 2018 in the record that supports these that has symptoms indicative of complex PTSD and reactive attachment disorder?
Yes, and sometimes these disorders mirror each other. So when you have young children, they really can't communicate. So the way that they are communicating is through their behaviors. Therefore, if you see some children, that's why you'll see lots of times when you're looking at records of young children, you'll see that different providers are giving them different diagnoses because some of them are similar or they mirror each other. Because again, children can't tell you what's going on with them. You have to see it through their behaviors and what the parent is experiencing at home.
We discussed earlier on, I guess I'll call it part 1 of this direct examination, about congruence and trust. Could you remind us about that, about the role of trust in human relationships?
Sustained.
So without reminding us about what you said, how is trust involved in the parent-child relationship?
Throughout you raising your children, trust is involved. You're teaching your children that you have to be able to trust them, and as they get a little bit older, you're giving them a little more independence, You're watching to see how they handle it. If they start to handle it badly, then you take away a little bit of independence, and so that trust between you and the child grows in that way. If you have a teenager and you let them use your car and they stay out too late, you take the car. I mean, that's good parenting. That's just parents that are teaching children, hey, I'm gonna let you get a little independent, but if you show that I can't trust you, I'm gonna pull back. And that's exactly how parents raise children that then learn to be responsible and accountable.
What behaviors are associated with a lack of trust, or someone that, perhaps someone would not feel comfortable trusting?
Objection, relevant speculation.
Sustained.
What evidence in the records have you reviewed that, well, let me ask it this way. Do you believe that a lack of trust, and I'm talking about this in terms of like psychology, your field, is there evidence in the record of doing activities that are not trustworthy?
Yes.
Object, improper opinion.
I didn't catch the last part of that question. That are not what?
Trustworthy, just because we're using that language in the psychological sense, Judge.
So is this a psychological opinion you're asking, or just her?
Psychological opinion, Judge.
And what's the basis of the objection? Sustained. Commenting on the credibility.
not commenting. So let me start with this. What are behaviors that indicate that's a lack of trust?
I'm going to object to relevance.
Sustained.
If you have someone who is doing things like stealing or lying, are those behaviors that show that, you know, they're tied to like manipulation or dishonesty? Is that fair to say?
Objection, improper opinion, improper character evidence.
Sustained.
Can you just,
Let me have you approach. All right, the objection sustained. You may rephrase, Ms. Moran.
does trust affect how a parent responds to a child?
Yes.
Explain that to us, please.
Yes, so as a child proves themselves to be more trustworthy and doing things that are, you know, they're accountable and they're responsible, then the parent learns to trust that child, gives them more independence, and, you know, the child moves on into adulthood.
In your review of the records in this case, is there indication that the Ferriters responded to that lack of trust from?
Objection, speculation.
Overruled. You have to answer that with reference to what you actually viewed as far as the records that drive your opinion or answer.
Go ahead.
So will you ask it one more time?
Sure. Is there evidence in the record that that sort of the parent's response to that lack of trust happened in this case?
Yes.
Okay. Without discussing the specific information in the record, explain to us how you've come to that conclusion. I know that that's hard.
It's hard. So there would be behaviors by whether it was at school or at home, and those behaviors would elicit a consequence.
Is there, how do parents, again, I'm talking about in psychology, when a parent sees sort of a lack of trust, how does that parent respond?
Normally, what you will see is a parent that tries to gain control of that child. So the more the child seems out of control, or the more the child seems untrustworthy, the more the parent then tries to put control on them, put external control around, or keep them somehow, you know, safe, or whatever the parent is going through at that time. So I think the parent's initial reaction is to clamp down and be more controlling of a child that they feel like is out of control.
Is that a normal or natural response by a parent in that type of situation?
Yes, in my experience working with parents, that's the first thing they try to do, is to you know, see if they can't gain some control over a situation they feel is out of control.
I now want to get into another opinion of yours. So you did, in fact, review the trial testimony and the deposition of Dr. Wade Myers, correct?
Yes.
And Dr. Wade Myers testified that the Ferriters engaged in malicious punishment. Is that correct?
Yes.
Do you have an opinion as to whether or not the Ferriters did, in fact, engage in malicious punishment?
Yes.
What is that opinion?
I don't believe that they were malicious insofar as they were deliberately trying to abuse and hurt their child. I think that they were responding to behaviors that they were very concerned about, and they were trying, it's almost like they went into a let's contain and monitor and make sure that nothing's going to happen. Did they do something appropriate? No. Did they handle it appropriately? No. But I don't think it was just an arbitrary, I'm going to abuse this child, be cruel to this child for no reason. I think in their mind, they were trying to contain some behaviors and keep everybody safe in the process.
There are records that indicate that the Ferriters went from sort of provider to provider. perhaps not staying with one for a very extended period of time. Do you have an opinion about that?
Sure, I see that happen all the time. Unfortunately, I wish I could say that all mental health professionals are excellent at what they do, but that's not necessarily the case. And sometimes you go to a provider that, what they're dealing with is a little over their head, or what they're not trained in evidence-based treatment, so they're trying to do talk therapy with a 7-year-old, which doesn't work. And lots of times I think that even us as clinicians, we kind of sit back in our world of theory, and this is how things are supposed to be theoretically, and this is how you make a perfect family, and this is how you do it. And so you just tell your child, you need to talk about your feelings, and every time the child is out of control, you sit down and calm them and say, talk this out with me. That's theory, and it's beautiful parenting, but it doesn't always work when the gravel hits the road. So lots of times parents will, in my experience, get frustrated at mental health providers because mental health providers try to make it sound like it's just so easy to do. But they're not the ones that go home with a child that's tantruming for an hour or an hour and a half, and they don't know how to soothe them.
We've talked about a couple potential diagnoses for. Is the actual specific diagnosis really does that determine whether or not you believe that there was malicious punishment? Like the specific diagnosis that may or may not have?
No, I don't think the specific diagnosis. I think in terms of maliciousness, maliciousness for me would mean that somebody would be arbitrarily abusing somebody with the purpose of making things worse for them. I think that when we see the behaviors that were being displayed and some of the behaviors that were happening, that they weren't necessarily being malicious. They were trying to contain and control it in a very inappropriate way.
Do you have an opinion as to whether, based on the records that you reviewed, was a danger to himself and others?
Your Honor, I'm objecting to the approach.
You can approach. We're going to take a 5-minute break. Council needs to review something before we proceed further. All right, go ahead and have the jury retire to the jury room. All right, and it's going to be 5 minutes sharp, Ms. Murad. If you don't have what you intend to present to the court, we're moving on.
Understood.
It was disclosed. I'll look at it.
Your Honor, may I state for the record what's in the deposition?
Yes, go ahead.
Okay. So, Judge, Dr. Rappa was deposed twice, once on September 20th by the state, a second time on September 27th by the state. The state asked on page the bottom of page 11 of the first deposition, I want to just kind of start with what opinion you expect to give in this case. It gets very lengthy, but she states several opinions that she would give. This includes, as he kind of got older and his behaviors got what they thought were more dangerous or more intense in terms of feeling or in terms of hurting other people or hurting themselves, that they, started thinking that we need to manage these behaviors, and the behaviors are so out of control, how can we manage them? And of course, the way they chose to manage them was probably the worst way anyone ever could. Then she said, what else? And that was on page 12. Page 13, lines 7 through 15, where Dr. Rappa describes sort of at length what her opinion is, and then the state goes specifically. In the second deposition that the state took, I had asked Dr. Rappa whether or not in a clinical setting she makes determinations about whether or not a child is a danger to themselves or others. Ms. Coakley specifically, and that was on the second deposition taken on September 27th of 2023 by the state, page 35, lines 7 through 15. The state also asked Dr. Rappa, this was regarding something different that was said in the CPT interview, about whether or not is it appropriate to, as a child is using the restroom, sort of have the door open, as there were allegations of that in the CPT interview. And Dr. Rappa said that where there is a danger, that is something that happens in a clinical setting, and that is on page 19 of the September 27th deposition. It's sort of at the end of page 18 all the way to page 19, ending at line 5. As to the oppositional defiant disorder, that is on the September 20th, 2023 deposition, page 38, line 8. Let me just get there. This is the state's questioning of Dr. Rappa. It starts on page 37. I think on page 38, the relevant line numbers would be starting at line 2. Ms. Coakley says, and there's also several other disorders that can share symptoms or overlap or share features, right? Dr. Rappa says, yes. Conduct disorders can. I see you nodding. You just have to say yes. Dr. Rappa responds, yes. The state then asks oppositional defiance disorder, and Dr. Rappa says, yes. And then she lists several other anxiety disorders, social phobias. She lists several other things. So I think in addition to the depositions, in the records that the state was provided, has been diagnosed with oppositional defiant disorder and reactive attachment disorder.
Ms. Murad, in any of those, because what you just read doesn't even get close, in my view, of being an opinion being rendered by this witness as to whether she had, based on her review of the records, reached an opinion as to whether ODD was applicable, or based on her review of the records, she had reached an opinion that the child victim was a danger to himself. Just mentioning ODD or being a threat to someone's self is not the same as an expert providing an opinion as to whether that is in fact her conclusion. Do you have anything that indicates that that was her conclusion that she was drawing, that the child victim in this case was suffering from ODD or was a danger to himself, as to which the parents had to respond?
I don't have anything additional to what I've already cited on the record, Your Honor. However, I will say that the idea that the state was not on notice or able to explore this in their own deposition, just as we were in our deposition of Wade Myers, I think is not fair.
All right. Well, whether it's fair or not, I'm not going to comment, but both sides know that trial is not the time for dropping new opinions with an expert witness, and I'm not going to permit it in this instance, so I'm going to stay with my original ruling that the questions concerning this witness's opinion on ODD or that the child victim was a potential threat to himself have not been properly disclosed, and therefore they're not going to be permitted to be introduced in this trial. Ms. Murad, anything else you wish to make for the record before I bring the jurors back out? All right, thank you. Mark, you may go ahead and bring the jurors out. And Ms. Murad, you may continue with your direct. All rise.
Jury entering.
All right, everyone may be seated. Thank you. You may continue, Ms. Murad.
Thank you, Your Honor. When we talk about reactive attachment disorder and complex PTSD, are there behaviors associated with those diagnoses that can become harmful or dangerous to people, to the child or the people around them?
Yes.
Are those behaviors exhibited in this case?
Yes.
Take us through how you've come to that opinion.
Okay, so we know that as early as 2015, some of the symptoms that are being documented for the child include things that are emotional lability, like the temper tantrum, sleep issues, anger and frustration, anxiety and fears. This is, kind of how we pinpoint PTSD in a child, especially in a very young child, because, again, they can't really tell us what's going on. There were also indications in the records where there would be inappropriate behaviors that were hurtful toward other people, and maybe not, maliciously done by the child necessarily when he was young, but so impulsive that, if the thought crossed his mind, he would go ahead and just do whatever it was that he thought about, and it would result in somebody getting injured. There were also, records that suggested that he was doing things that were dangerous in the home, and dangerous to other people that lived in the home. So, and that's not an uncommon thing when you see children with reactive attachment disorder, because those children really do have very active minds, and while they can be very impulsive when they are emotional, they also can be kind of calculated. They can figure out something that they want to do or take apart, or how they can steal something, or how they can pull something over on an adult, and then they're able to do that. So you get kind of both of that with a reactive attachment disorder child in it, and these things make them dangerous to themselves many times without them even realizing it, and dangerous to others.
Is there evidence in the record that prior to 2018 there were issues with roaming around the house at night?
I'm going to object.
Sustained.
Did you rely on records that indicated sort of wandering or eating at night?
Objection, hearsay.
Sustained.
Based on the records that you reviewed, sort of what, do you have any opinions as to why? So you mentioned that his behaviors didn't have predictability. Is that fair to say?
Didn't have what, I'm sorry?
Predictability.
Correct.
Why is that concerning for a parent?
When you have behaviors that aren't predictable, and the child is trying to kind of outsmart you or get one over on you, you're not quite sure what's coming next. So sometimes what's coming next is something that can be pretty dangerous.
Objection, speculation.
Sustained.
I move to strike, Your Honor.
Answer. The last part of the answer is stricken. Jury is instructed to disregard it.
Is there evidence in the record, as you just stated, that one was exhibiting dangerous behaviors?
I'm going to object.
Sustained.
I want to talk about a particular, admitted in his trial testimony that you've reviewed in coming to your opinions, correct?
Yes.
That there was a search that he made on his school laptop for something very violent. Are you aware of what the substance of that search was?
Yes.
What was it?
I'm going to object as to hearsay.
Sustained.
What is, can you explain to us how the searches that people make, like why is that relevant in determining anything about someone's, whether or not that person is a danger?
When you're looking at it,
Object, improper opinion, and not disclosed.
Approach. All right, objection sustained. Ms. Murad, you may continue.
Is it your opinion that the Ferriters were responding to its behavior?
Objection, speculation. Also asked and answered.
I'm going to overrule in part, sustained in part. You can answer it, but it has to be solely with reference to what you observed and reviewed in the records that you reviewed in connection with your opinions as an expert in this matter.
Will you ask again?
Sure. Is it your opinion that the Ferriters were responding to its behavior?
Yes.
And is that behavior indicative of early childhood trauma?
Yes.
Do we see Ronan's behaviors or the ones that the Ferriters are responding to prior to May of 2018?
Objection.
Sustained.
Did you rely on records in coming to your opinion before 2018?
Yes.
No further questions.
All right, Cross, Ms. Copeland.
Morning, Dr. Rappa.
Good morning.
So you were hired by the defense in this case.
Yes.
And you charged them a fee. What was your fee in this case?
I charge $350 an hour. As of today, I have made $5,000.
And then there'll be an additional amount for testimony today.
That is correct.
Preparation for this type of thing, correct?
Yes.
Now, today, your work is mostly in the courts.
Correct. 100%.
Right. And mostly criminal cases, correct?
Not necessarily. I do a lot of civil cases also.
But as a court psychologist or a forensic psychologist, that means that you do things like competency evaluations for the court?
No, ma'am. I don't do very many competency evaluations. I'm not on the wheel or get appointed by the court for that. Occasionally, I might do one for a criminal attorney, but it's very rare.
You do insanity evaluations sometimes?
Yes.
Whether or not someone was sane at the time of the trial?
Yes,
You do risk assessments for sex offenders?
I do.
You do assessments for criminal defendants in general to make a determination for things like sentencing,
Yes,
to
I do.
advise the court. You haven't been involved in any publications related to childhood trauma, attachment disorders, or bizarre punishment, correct?
I have not.
And you don't do peer review for that type of stuff for scholarly journals.
I do not.
And while over the course of your career you have treated patients, you don't treat reactive attachment disorder.
I don't. I treat early childhood trauma. I have no issue with that. But once it gets into persistent reactive attachment disorder, no, I would refer that out.
You would send it to another professional in the field.
I would.
And while you have testified as an expert in court on a lot of different topics, a lot of different psychological issues, you've never testified in court before on a case involving extreme, bizarre, or malicious punishment, correct?
Yes, I believe that's true.
So this is the first one.
Yes.
Now, I want to talk about the items that you reviewed in this case. You did not speak to the defendants, correct?
That's correct.
And so your assertions about what they intended or what they thought or what they were trying to do, that's not based on any direct information that you have, correct?
That's right.
You don't actually know for sure what they were acting on or what their intentions were, correct?
No, I have not spoken to them, so I would not know their intent.
And you didn't actually speak to anyone in the case. You reviewed the records similar to Dr. Myers.
Yes.
And when I say that you reviewed the records, there's records from some prior practitioners. You didn't speak to them either, correct?
I did not.
Now, I want to talk about your opinion. You can't give a diagnosis in this case, correct?
I would feel very uncomfortable giving a diagnosis without interviewing someone.
Okay. And so part of that is that you have insufficient information to make a definitive diagnosis, correct?
Right, because I'm missing that interview portion.
But you do have an opinion on whether or not the defendant's actions were an appropriate way to manage the behaviors in this case, correct?
Yes.
It is your opinion that the way that they chose to manage the behaviors is probably the worst way anyone could ever manage these type of behaviors, correct?
That's correct.
Now, although you can't make a diagnosis, you think that there are indications that the child in this case has complex PTSD as well as an attachment disorder, right?
Yes.
And if a child does have an attachment disorder or complex PTSD, the way the defendant acted towards the victim is the complete opposite of what anyone should have done with a child with one of those conditions, correct?
Yes, ma'am.
In fact, confining and isolating a child can exacerbate those disorders, correct?
That's right.
And so exacerbate means make those symptoms worse,
Yes.
correct? Even in a child that doesn't have PTSD or an attachment disorder, this type of treatment of any child creates a risk of harm to that child, correct?
I agree.
To both the mental and physical health of a child, correct?
Yes.
So there is a reasonable likelihood that of psychological harm to a child that is treated this way, even if that child does not have any underlying issues.
I agree.
Isolation is not something that is used for children, correct?
It should not be. People
Right.
do, but it should not be.
Right. It's not recommended.
That's correct.
It's not considered acceptable within the psychological, within the child abuse community, really within normal community, correct?
Yes.
Now, I want to talk about some of the records specifically that you reviewed. You reviewed some emails from Immaculate Heart, correct?
I did.
That is where the child in this case went to elementary school, correct?
Yes.
So he's in 4th, 5th grade when he's at Immaculate Heart, correct?
Yes.
And if we do the math, that means he's about 10 and 11 years old during that time frame, correct?
That would be right.
So you reviewed an email from February 13th, 2018, which was one of the things that the parents got notified of, a behavioral problem by their son, correct?
I'm not, without having it in front of me.
Sure,
I'm
I
not
can get
sure,
it if you
yes,
look. But
I
there
did
was,
look it
one of
up.
those emails was about because he was using a bad word, correct?
That's correct.
That's one of the things that they got contacted about, correct?
Yes, he used the F word.
Right, and he said that using bad words makes him feel bigger, that he can be protected from the bigger kids if
Yes.
he uses bad words, correct?
He did.
He's 10 years old at that time, correct?
That's right.
On February 28, 2018, he punched a kid, correct?
Yes.
And that was in response to getting kicked, correct? That's the information.
That's what he said, yes.
That was the information provided to the parents, correct? 10 years old still at that time, correct?
Yes.
On May 15, 2018, we had that incident where he pushes another child against the wall with his fingers on the child's throat, correct?
Yes.
And the teacher concluded in that case that both children were not saying nice things to each other in that incident, correct? That kind of proceeded.
That's what she wrote, yes.
Right. And at that point, the child in this case was 10 years old also, right?
Yes.
There's October 29, 2018. That email is about roughhousing during a game. That's how the teacher put it, that he was roughhousing, right?
Yes.
December 3rd, 2018, they also got contacted, and it's because he stole a piece of candy off his teacher's desk.
Yes.
January 29th, 2019, he kicked a ball at a student, correct?
Yes.
And he got punished by the school by sitting out of recess and writing a letter of apology.
Yes.
And February 2019, they also got contact because he stole a container of sprinkles.
Correct.
He's 11 years old when he stole the sprinkles from school.
I would say so, yes.
February 2019,
Yes.
10 or 11. February 2019 is when there was a mutual physical altercation with another student,
Yes.
where they get into a fist fight, the little boys, and they're both punished. They both get detention.
Yes.
And March 8th of 2019, that's when there was the technology issue, and he was found with a calculator, right?
Yes, he had stolen a calculator, correct.
And then March 22nd, 2019, he embarrasses his sister in class, correct?
Yes.
And that's about a month after his brother is born,
Yes.
when we know, based on the timeline, that he's already living in the garage that they built for him in Arizona, correct?
Yes, he would be by then.
A 5th grader, 11 years old.
Correct.
And then March 27, 2019, he uses inappropriate language again. He says another bad word.
Yes.
So between 2018 and 2019, at the elementary school, there's 2 incidents that involve physical contact with another child. The fighting incident and the push
holding
against the wall.
Against the wall, yes.
For the large part, every other behavioral incident was something like saying a bad word or stealing a piece of candy or stealing another item.
Yes, that's correct. It's stealing or the candy, and then the humiliation of his sister, which I think was on a whole different level.
He got up in front of the class and he made her cry in class.
I mean, I think that if you look at it that way, it looks, kind of simple. He got up in front of the class and made fun of his sister or said some things. But
that, I mean, that's what occurred, right? My question is, that's actually the action that occurred, right? He's in the 5th grade, 11 years old, and he says something mean in front of the class about his sister, correct?
that is what happened.
Okay. Now, I want to talk for a second about that neuropsychological exam that we discussed. And that neuropsychological exam happened in October of 2022.
Yes.
So on the timeline, this occurred after the defendants were arrested and were charged with child abuse, correct?
That's right.
They did not have any of that information about the neuropsychological exam prior, correct? As far as you know.
Yes, correct.
And there's no indication from the records you reviewed that the defendants ever sought a neuropsychological evaluation prior to being arrested for child abuse, correct?
That's right.
And there is background information, I think you talked about it with the defense, that is self-reported, correct?
Yes.
That means that there is information that the child provided, and then there's also information that Ms. Ferriter provided, correct?
Yes.
And because of that, the report includes a limiting instruction or a cautionary instruction, correct?
Yes, all reports would.
And that information was provided after Tracy Ferriter had already been charged and arrested with the abuse of her child,
Yes.
correct? And the report itself contains the caveat that because it in part relies on self-reported information, it is limited in extent, correct?
Yes.
That it's highly subjective,
Yes.
correct? And it may contain errors of interpretation, correct?
Yes.
And also omissions.
Yes, people are giving you their own perspective of the situation.
And you talked about those neuropsychological the results, and there was, in part, some difficulties in executive function and impulse control, correct? Right? That was two of the things that report found, correct?
Yes.
And both of those things can be the result of trauma, correct?
Yes.
And ongoing abuse throughout a child's childhood could make issues with executive functioning worse.
Absolutely.
It also could make, if there's ongoing abuse throughout childhood, it can make issues with impulse control worse, correct?
Yes.
Anytime you take a child who has an early childhood abuse or neglect, and then you add to that, it's going to exacerbate any symptoms that they have, correct?
Yes.
So if you take a child that has early childhood neglect or an adverse childhood experience, right, like in the orphanage, that would be an example of an adverse childhood experience, typically, correct? If you take a child like that and then you subject them to additional ongoing abuse, that might exacerbate their symptoms, correct?
For sure.
Now, the report that we're talking about also talked about that the victim in this case had some difficulties in executive functioning, correct?
Yes.
And the way in which he was treated has the risk of increasing those difficulties, correct?
Yes.
He also had, you called it some difficulties in self-monitoring. The way that he was treated would increase the difficulties in self-monitoring, correct?
Sure.
You also mentioned that it was determined that there's some difficulties with emotional regulation, correct?
Yes.
The way that he was treated would increase his difficulties with emotional regulation, correct?
Yes.
Now, a child that has these characteristics that you said that were clinically significant, it is never an appropriate treatment for those types of clinically significant difficulties, the way he was treated, to confine him.
Yes, you're right.
You also noted that there was some difficulties in impulse control, but confinement is never an appropriate treatment for those difficulties either, is it?
That's correct.
And this report that occurred in 2022, it actually didn't come to the conclusion that he had reactive attachment disorder.
No, I believe he gave him an impulse control disorder.
And these types of difficulties that you talked about, difficulties in impulse control and executive functioning, they're not actually part of the diagnostic criteria for a reactive attachment disorder.
That's right.
Right? Individuals who do not have reactive attachment disorder can get these same results.
Sure. I mean, if they have a disorder of impulse, they can get it just because of that.
And these are areas of the brain that you also see impacted by someone who has PTSD.
Yes.
Okay. Now, want to talk about additional thing you reviewed. You said one of the things that you reviewed was the deposition, and I think it noted that the deposition was 5 hours long.
Yes, it was long.
That's a long time for any person, never mind a child, correct?
Yes.
And it's sometimes people, when discussing things, even traumatic things, respond in a way that is not necessarily considered normative or appropriate, correct? Sometimes people laugh inappropriately.
Sure.
Now, I want to talk about reactive attachment disorder more specifically. So, reactive attachment disorder is a diagnosis that's in the diagnostic. Tell me what it's called, the DSM. What does it stand for?
DSM-5, the Diagnostic and Statistical Manual.
And so that is the manual that psychiatrists and psychologists use that sets out the standard diagnostic criteria for a lot of psychological and psychiatric conditions.
That's true.
Also has some behavior disorders, some personality disorders, lots of different things. But it's a standardized way in which we evaluate if someone meets those criteria, correct?
That's right.
And you couldn't formally make the diagnosis in this case of reactive attachment disorder.
I did not, no.
But your opinion that there is some reactive or there's some attachment disorder characteristics here is based on the review of records of other people, correct?
Yes.
You don't know the methodology that any of the other people who looked at him relied upon, correct?
Yes, I don't know specifically. I know if they're licensed, then they would have to abide by, whatever their professional license is and the DSM to make a diagnosis.
But the reports that we have don't go into the underpinnings of their diagnosis, correct?
No, you wouldn't necessarily get that from anyone exactly how they got to their diagnosis, but you would assume if they're licensed that they have taken tests and been educated and supervised and know how to diagnose appropriately.
One of those people that made a diagnosis is a Mr. Kenny Miller, correct?
That's correct.
He is actually a licensed clinical social worker, correct?
Yes, he is.
So that's a master's level practitioner, right?
Yes, he is.
Not someone who has a doctorate like yourself or Dr. Myers.
Correct, but I will say that some of the best clinicians I've ever met in my life are licensed clinical social workers. So just because they have a master's degree as opposed to a doctorate doesn't necessarily make them a lesser clinician.
You actually, though, don't have any of Mr. Miller's clinical notes, correct?
I do not. Only what I was given, which I believe was a letter talking about when he had talked to the Ferriters and when he had seen them.
Okay, so you don't have any of the treatment progress notes that were contemporaneous to when he was treating in this case, correct?
Yes, I do not.
The only thing you have is a letter that he wrote after the defendants were arrested, correct?
Yes.
And the letter doesn't explain the diagnostic criteria, correct?
Not at all.
It doesn't indicate if he even met with the child. It's kind of vague as to whether or not he did.
I think he said he met with the child.
Right, but it's unclear once, twice, beyond that.
Right. That was hard to determine how many times he had met with the child, how many times he'd met with the parents. But he did say they had ongoing communication.
And if he did, in fact, meet with them, the time frame that we're talking about is after the child, the victim in this case, was 10 years old, correct?
That would be right.
And you're familiar with the DSM and the criteria that they have for reactive attachment disorder, correct?
Yes.
That manual also provides some cautionary instructions that practitioners should take into consideration when reaching a diagnosis, correct?
That's true.
And some of those cautionary instructions as it applies to reactive attachment disorder is that it shouldn't be diagnosed after the age of 5. Or if it's done, it should be done with extreme caution.
I agree
correct?
with that.
That's what the DSM says?
Yes.
And based on the very limited information we have from Mr. Miller, we don't know why he is making that diagnosis after 5 years old, correct?
Right, I'm not sure why. I'm assuming that he would make a diagnosis the way anybody that is licensed would make a diagnosis.
And then you also review the records of a Dr. Reichenbacher.
Yes.
I'm saying that correctly. And Mr. Reichenbacher is a psychiatrist.
Correct.
And he, you have some of his treatment notes from his meetings with the family and the child, correct?
Yes,
He notes reactive attachment disorder and ADHD, correct?
he does.
But he has no indication of the appropriateness of whether or not why he's making that diagnosis after 5 years old, correct?
Right, I don't think that you would normally see in somebody's treatment summary how they arrived at that diagnosis. You would see the diagnosis that they rendered, and you would assume that it was because they had records available or interview available, however they made the diagnosis. But we would assume if somebody is licensed that they're giving a diagnosis based on their professionalism and their knowledge.
Right. And so you're making some assumptions about what they're relying upon because we don't have any additional information, correct?
Right, but there are standards and rules of how we diagnose somebody. So it would be very rare indeed for somebody to be diagnosing out of the blue with no information whatsoever.
Now, in looking at Dr. Reichenbacher's notes, there's no indication of whether or not in making his diagnosis that he was aware that during this time frame, the victim is being confined in a structure that his parents built in the garage, correct?
Right, that is not in his notes.
There's no indication that he was aware of that, correct?
Correct.
And that would be important information for a psychiatrist to have in making a differential diagnosis.
I think so. I would have liked to have that information.
Now, Dr. Reichenbacher saw between December 2018 and January 2019, correct?
Yes.
And so the last time we have of him being involved in all was January of 2019, correct?
Yes.
Which is 2 years prior to the arrest in this case?
Yes.
Now, there's a handful of meetings, 3-4 meetings total, correct?
That's right.
And the meetings, aside from the initial assessment, are about 20 minutes long.
Yes.
And the victim in this case is 11 years old at the time.
Yes.
And so in December 2018, they have their initial evaluation, correct?
Yes.
And the recommendation is that perhaps the victim in this case may need behavioral therapy.
Correct.
And then in May 7th of 2019 is the next meeting,
Yes.
correct? And it's noted from the report that the parents reported to their psychiatrist that they were seeing for the behavioral problems of their child that he is not having severe aggressive behavior at school. That's what the parents report, correct?
Yes.
And they also noted adequate behavior at school regarding focus and hyperactive behavior, correct?
Yes, he had been placed on medication at that time.
And then the doctor decided at that point that the treatment going forward would be to continue medication and therapy, correct?
Yes.
But there was a problem because the parents were going to go away for the summer, so he might not be able to get that therapy.
I don't remember why they didn't, but they didn't get the therapy at that time.
Now, in January 23rd, 2019, they also went back to Dr. Reichenbacher, correct?
Yes.
And the chief complaint that his parents brought was that he has some anger, correct?
Yes.
And the mom reported some improvements in his ability to not get angry or apologize and later on, correct?
Yes.
And the child got tearful when his mom was talking about him, correct?
That's what the report said, yes.
And they reported that he had not been seeing a therapist at that point. And the doctor, again, recommended that they should do medication and meet with a therapist, correct?
Correct.
At no point did Dr. Reichenbacher recommend confinement
Never.
to the parents. And at no point did the parents report that there was issues with the child hurting animals, correct?
To that doctor?
To Dr. Reichenbacher.
Right, to that doctor, no.
And I think that you mentioned that was something that may have existed in this case, but isn't it true that the only issue that he ever had with an animal is when he overfed a dog?
No, he had been riding a bicycle and was riding the bicycle into the dog.
Okay, so he hit the dog with a bicycle.
Yes.
And you know that in 2022, in January, at the time that we're talking about from reviewing the videos, that there were times where the child is allowed to be alone with the dog?
No, I didn't.
You didn't see that? There's times
I did see him out with the dog, but he wasn't, the family was around.
Okay. Did you see any of the videos where he's alone with one of the dogs in the room, in his structure in the garage, locked in the room, and the dog's in there?
Oh, I didn't recall that.
No. Okay. And there's other times that family had multiple pets where he's allowed to be around with the pets?
Yes,
Correct?
I mean, I definitely saw him with the family with the pets.
Now, going back to reactive attachment disorder, social and the diagnostic criteria, social neglect is a necessary condition, meaning that there has to be a time in the early childhood where their child was subject to extreme neglect, correct?
That's right.
But it doesn't necessarily mean that just because that occurred that a child is going to have reactive attachment disorder, correct?
That's right.
And when a person has reactive attachment disorder, there's actually two types, correct?
Yes, it's been divided into two types.
There's one where the child is overly affectionate, almost indiscriminate with their affections towards adults.
Yes.
That does not seem to be the case here. There's no indication of that.
No.
So that's not what we're talking about here.
Correct.
The other one is when the child has difficulty forming attachment, correct?
Yes.
And there's nothing in the criteria or what we're looking at in diagnosing it that has anything to do with violence.
No, it's only if the child will refuse to be comforted by a caretaker or will not go to the caretaker to be comforted. So it's very specific.
Okay, so you saw a lot of times see a child that appears withdrawn or unable to be comforted by an adult.
They're not necessarily withdrawn, but they're unable to be comforted. So they're having intense temper outbursts, and the parent goes to comfort them, and they don't want that. It makes it worse, actually. Or the child hurts himself or is out of control emotionally and won't go to that parent for soothing. So it's a very disturbed way of attaching.
Right, but there's nothing in the criteria that says that the child has to react towards themselves or others in a way that involves violence.
No, I mean, not necessarily. But when you look at it and when you look at reactive attachment disorder as it is studied, these are the behaviors that are seen in the studies when people are diagnosed with this.
Now, when people are diagnosed, the DSM tells us to, and I think you've already agreed, that after 5, it should be done with extreme caution. And that's in part because it is unclear if reactive attachment disorder even occurs after the age of 5, correct?
Sure. So what happens is many people, some people are in the camp that, you know, you can have persistent reactive attachment disorder that goes through middle childhood, through adolescence, into adulthood. Some people are of the camp that, hey, it's reactive attachment disorder, but really what's underlying it is that complex PTSD, and that's why we see it continue throughout the lifespan. So it really just depends on what camp you're in. There's a little bit of research for both.
Now, according to the DSM, the reactive attachment disorder is incredibly rare, correct?
Yes, it's not something that you would see often in your practice.
And you're familiar, and it's something that is considered that has a high risk of misdiagnoses, correct?
I think that it did back in the day when people were first hearing about it and calling everything that a child did rad, you know, everything was rad. I think now clinicians are way more cautious about diagnosing, but when you see somebody like Ronan that has that really severe neglect, malnutrition, scabies, I don't think that it's a leap. I think it's you know, it makes sense and based on his behavior.
Well, you're a member of the American Professional Society on the Abuse of Children, correct?
I am a member, yes.
And that is, it goes by the acronym ABSAC.
That's right.
And as a member, you stay up to date on the professional recommendations and also ABSAC's positions on the latest research and community standards for the treatment and for child abuse, correct?
Correct.
And ABSAC, the task force, issued a report on attachment disorders and attachment problems, correct?
They did.
And the report points out that that reactive attachment disorder is actually incredibly rare, correct?
I agree with that.
And they also point out it's also known that there is an inappropriately high number of children misdiagnosed with those, especially those who have only a mild or moderate symptoms, correct?
Yes.
And the report points out that, and I think you already discussed, that there is incredibly abusive ways in which sometimes reactive attachment disorder gets treated.
Yes.
That includes extreme control over every action that the child has, correct? In extreme circumstances.
Yes, it's parents that are desperate parents trying to control these behaviors, and they're controlling these behaviors in ways that are detrimental to the child.
That are harmful.
Yes.
And the report points out that one of the key things for treating reactive attachment disorder, or ways in which it is recommended in general to be treated, is it focuses on actually the actions of the parent as opposed to the child.
That's correct.
The most effective therapies actually don't rely upon the child, correct?
It's mostly teaching the parent how to parent that type of child, because parents think, especially foster parents or adoptive parents, think that love is enough. And if they just lavish this child with love, this child's going to get better. And it's very frustrating for that parent when they're trying to do all they can and the child is not changing or getting worse.
Now, I want to talk about hoarding food. Hoarding, stealing food is something that you see commonly in children that have a history of deprivation or come from deprived or neglected backgrounds, correct?
That's right.
And the way in which to deal with that behavior is not to limit access to the food.
It depends. Now, there actually are many foster parents that put locks on their refrigerator because during the night the kids will get up and they'll eat every single thing. So I think that there is a way to therapeutically put some limits, but to take food away from child or not let them have food, that's totally inappropriate.
Now, let's talk about PTSD. You said that it's your opinion that there is complex PTSD here that occurred in the early childhood, correct?
Yes.
The DSM also sets criteria for post-traumatic stress disorder, correct?
It does.
And it has a separate criteria for children that are over 6 and children that are under 6, correct?
Yes.
And the first thing in order to be diagnosed with PTSD is you have to directly experience a traumatic event, correct?
That's right.
And it gives examples of traumatic events, but there are things like actual threat of physical violence, death, bodily harm, correct?
Sure.
It doesn't talk about lack of food or being in an orphanage. There has to be an actual physical violence experienced by the child, correct?
No, I totally disagree with that. I don't think that the DSM-5 could list all the different types of trauma. And I think severe neglect absolutely would be part of severe trauma for children. Also, you say bodily injury. Starving a child and giving them sugar water is bodily injury. So yes, these children are experiencing trauma and they're experiencing bodily injury. They're just not old enough to talk about it.
So the DSM says exposure to actual or threatened death, serious injury, or sexual violence in one or more of the following ways. Directly experiencing the traumatic events, right?
Correct.
Witnessing in person the events as it occurred to others, especially primary caregivers, correct? Or learning that the traumatic events occurred to a parent or caregiver, correct? Those are the 3 things that they have to directly experience, correct?
It could be either one of those.
It could be any of those 3, and the alternative.
He had directly experienced it.
Now, you also said that it can occur in infanthood, but the DSM says that PTSD can occur beginning only after the first year of life, correct?
You would wait till they were like 9 months old before you would diagnose that. But again, it would be diagnosed not through the DSM if they are a young child. It would be diagnosed through the diagnostic classification 0 through 3, which is a whole different book.
Okay. But the DSM, right, the Diagnostic and Statistical Manual of Mental Disorders, says that it's occurring after the first year of life, correct?
Right.
For PTSD.
I mean, that's what they say. And you're not going to necessarily diagnose PTSD until a child is a little bit older, because you would have to see emotional lability. You would have to see that child having difficulty sleeping. There'd have to be some symptoms that you're seeing that wouldn't be attributable to that child just being a newborn.
So in complex PTSD, you see interpersonal trauma, and these traumas have caused them to experience fear, horror, anxiety, to the point where they now have developed a disorder, correct? That's how you would describe it.
Yes.
And symptoms that you may see in a child that has, or a person that has PTSD, are emotional reactivity, correct? Emotional numbing, correct?
Yes.
Lack of trust
Yes.
and avoidance, correct?
Correct.
And there are treatments for PTSD even for young children.
There are.
And there is trauma-focused cognitive behavioral therapy, correct?
You can start that as early as age 3.
Some people do EMDR with children.
Yes.
And the focus is not on the behaviors when treating PTSD, but what's underlying those behaviors in terms of abuse and neglect, correct?
Exactly.
It would not be appropriate to confine a child to a room with PTSD as was done in this case, correct?
Correct.
That would never be appropriate, correct?
Correct.
Reacting to a child who has complex PTSD or an attachment disorder with things like anger and threats is not productive or helpful to a child with those conditions, correct?
Right.
And those reactions create a psychological harm to the child, correct?
Yes, and it can exacerbate problems that were already there, for sure.
Adding to the existing harm.
Yes.
Making it worse. I see you nodding. We just have to say
Yes.
out loud, yes. So PTSD can be worsened by ongoing abuse and neglect, correct?
Yes.
In fact, you would agree that there would have been damage done to the victim's neuropsychological health from the defendant's actions in this case, correct?
Yes, most likely.
It's your opinion that the way that his parents handled the symptoms from PTSD exacerbated it, correct?
I do believe that.
And this is not a way that a child with early childhood neglect should be parented, correct?
That's right.
Not only was it harmful, but none of the ways in which they addressed him or he was treated would be useful as constructive punishment, correct?
Right. No.
Now, I think that you also said when we spoke previously that there were some indicators that the child was experiencing some symptoms of depression prior to the removal from his parents.
Sustained. Next question.
Let's talk about abuse and neglect generally. Over the course of your career, have you come across cases where there was ongoing abuse and neglect, but the abuse and neglect wasn't apparent to others who interacted with the family?
Say that last part again. I'm sorry.
Have you come across cases of abuse and neglect, ongoing abuse and neglect, where that ongoing abuse and neglect wasn't apparent to people that interacted with the family?
Oh, wasn't apparent. Yes.
Sustained. You
Your Honor, if
you
you
want to
can
approach? You can.
Now, in cases involving abuse and neglect, can the child who is exposed to ongoing abuse grow a tolerance for the environment that they're in?
Overruled.
Yes.
And so even in cases where that environment that they're subjected to is abusive or neglectful.
Sure. Yeah.
So there can be a normalization of that type of treatment for the child.
Yes.
Now, I want to talk for a second. Just make sure I didn't miss anything. About the interventions that occurred. You talked a little bit about that. Defendant provided you with a attempt or a list of their attempted interventions, correct?
They did.
Based on the information available to you, the last time that the victim in this case was seen by a psychiatrist or a mental health professional to address any behavioral issues was mid-2019, correct?
That is true, although I did, after that, after our deposition, I did receive information that they had reached out to I believe, a medical doctor, a primary care physician, and were asking for referrals for a psychiatrist, but they were in the process of getting the referral from their doctor before he could go to see one.
Right,
and
so
that was more recent.
So the last time, though, that he was ever seen, as far as you're aware, by a psychiatrist or a psychologist was in mid-2019.
Yes.
And recently there might have been maybe we should talk to someone again, correct?
Yes, that's when they moved here.
Right, after they had already been confining their child for approximately 3 years, correct?
Yes.
They also provided you that they sent one email in December of 2022, or December of 2021, excuse me, that they reached out about a meeting with a transcendental meditation person.
Correct. They were trying to get into transcendental meditation to help calm his behaviors.
They sent one email in December of 2021, correct? Based on the information that you had.
Correct.
Transcendental meditation is not a medical doctor, a psychiatrist.
No.
A psychologist, a licensed clinical social worker.
I'm not sure who can do it, but I don't believe it is in the mental health field.
And based on the information provided to you, there were no counselors after that date either. He wasn't continuing to see a therapist or a mental health counselor or a licensed clinical social worker after mid-2019, correct?
Correct.
And based on the information provided to you, that he started being held in the structure in early 2019, correct?
Yes.
And there also was no indication that an individualized education plan was ever sought at his school.
Right. I believe he was in private schools, no? But no, they did not.
Yeah, so there was no individual education plan. And then when he came to Independence Middle in Jupiter, when they moved in December of 2021, January of 2022, there was no IEP sought, correct?
Right. I don't think that, I mean, they had just gotten there, and I believe it was over Christmas time. So I don't know that they would have been getting it that quickly. But no, I didn't see evidence of it being sought.
Did you see that they reported no behavioral problems when they enrolled him in to Independence Middle School in Jupiter?
I don't recall that, but I'll take your word for it.
Now, I want to talk about the impacts this type of treatment would have on a child. I think you've already said that it would exacerbate any pre-existing problems that the child may have, correct?
What would
the type of treatment, the way that he was kept and confined, correct?
Oh, yes.
Would it also, and isn't it true that it's your opinion that it will also make the child feel rejected, correct?
Yes, it could.
It make the child feel like they're not good enough, correct?
Yes, it could.
It make the child feel like they are inherently bad, correct?
Yes, it could.
It can lead the child to maneuver or manipulate through a situation to avoid that isolation.
Yes, it could.
It can lead to depression, correct?
Yes.
It can lead to suicidal ideation, correct?
It could.
When a punishment is chronic, meaning that it happens on an ongoing basis, you will see a bigger impact too, correct?
For sure.
And as to the victim in this case specifically, you think that what was going on with him, the issues that he was having prior, was really exacerbated by how his parents acted towards them, correct?
Yes, that's my belief.
There is a psychological impact, a negative one, when punishment is humiliating and isolating, correct?
Yes.
Now, as to the appropriateness of the punishment, it's your opinion that you don't think anything that they did or attempted to do that they did would help him be better, correct?
Sustained.
Isn't it true that it is not appropriate to punish bad behavior by placing a child in a situation where they don't have access to an ordinary bathroom?
Yes.
It's your opinion that should never have been done in this case, correct?
Yes.
That type of treatment is also humiliating, correct?
Yes.
The same is true for locking him from the outside. That is something that should never have been done, correct?
I agree.
That's also true for the inability to control the lights. That is inappropriate, correct? Inappropriate. That is going to have a negative impact on a child if it happens over a longer period of time, correct?
Yes.
Having a child sit in the dark in a locked room for long periods of time is not an acceptable form of punishment.
Sustained.
It is the type of thing that would cause harm, correct? That wasn't.
Sustained.
At no point is there any indication that these parents were advised to engage in this type of behavior, correct?
I didn't see any professional telling them to do that.
And that's because it would be something that would not be recommended by someone within the mainstream psychological and psychiatric community.
Yes, I'm glad you said mainstream, because absolutely there are many professionals that believe in a very militaristic type of parenting, authoritative type of parenting, strip everything out but their mattress, take their door off the hinges. There are professionals and paraprofessionals that do believe this is a way to parent, but people that are mainstream and that really know the research would never have suggested that.
Right. And there's no indication that even these non-mainstream people are involved here and said that you should do this, correct?
Right. I would not know that. Right.
The only advice that we know about is medication and therapy, correct?
That's correct.
That's all the questions I have.
All right, redirect, Ms. Murad.
Dr. Rappa, the state spent some time in their cross-examination sort of challenging the diagnosis of attachment disorder. So I want to talk about that, okay?
Okay.
Is your opinion solely based on the diagnoses that previous providers have made?
No.
What else is it based on?
I mean, that does help to know that previous providers had seen the same thing. But it has to be on behaviors and it has to be on early childhood experiences, especially as it pertains to children, you know, from birth to age 3.
And in the record, did you see those patterns of behavior that led you to come to your opinion about the attachment disorder?
I did. I saw the severe neglect. I saw the scabies. I saw the malnourishment. And then I saw the behaviors. Or not saw, I saw in the records. The behaviors.
And you reviewed Wade Myers' trial testimony. Did the state's own expert, in fact, testify that likely has reactive attachment disorder from early childhood neglect in his own testimony to this jury?
Objection, Your Honor. Hearsay, argumentative.
Sustained.
In reviewing Wade Myers' testimony, is it consistent with your opinion on attachment disorder?
Yes.
The state asked you about the deposition that you saw and his sort of affect and behaviors. And the state mentioned that, you know, it's long, he's a kid. Is that what you made of it, or his affect, that it was just because he was a kid and it was a long deposition, or were there actual things about his affect that were concerning to you in coming to your opinion?
There were things in his affect that were concerning to me that went on my radar as I was watching.
Could you take us through those?
Objection, ask the answer.
Sustained. You want to approach on that, Ms. Murad? Because I think she testified to that in her direct.
I think she did as well, Judge. That's fine.
I sustained.
And so you
Objection
maintain the
sustained.
you maintain the same opinion you had in direct examination, correct?
Yes.
The state mentioned, it sounds a little silly in retrospect, but something like transcendental meditation. Did the Ferriters sort of try both medical and non-medical options over time?
Objection, hearsay.
Overruled. You can answer.
Yes, they did. They tried many different things. They tried putting him into like karate, and they tried chess club, and then they tried to burn his energy off with track. They did
Let me
try.
stop you. Are you testifying from your review of the documents that you reviewed as part of your opinion? Or are you testifying from conversations with somebody?
No, sir, I didn't have conversations.
So, all right, so I'm going to allow the answer. You can continue.
Thank you. Go ahead.
They also tried putting him into a meditation class so that he could learn to control his behavior. So I think they tried nutrition, they tried taking away gluten, they tried taking away sugar. I mean, there was a bunch of different things that they did try that were outside of the mental health world.
Based on your experience sort of working with families and particularly children with a history of trauma and their parents, I mean, is that, I guess, what do you make of that? Was that neglectful of them and not pursuing every medical option? Or is it something that parents do in trying to?
Objection, improper opinion.
Sustained.
The state mentioned the transcendental meditation, and you mentioned several other efforts that the Ferriters made. Those are obviously not medical efforts, correct?
Correct.
Does that change your opinion as to whether or not they engaged in malicious punishment?
No, it does not change my opinion.
Why not?
I think that they were trying the best that they knew and what they.
Sustained.
Without what you think, so the state's expert testified that based on the Ferriter's conduct, he believed that there was malicious punishment, correct?
Objection leading.
Finish the question. You hadn't finished. I hadn't gotten to the. You hadn't gotten to
Sure.
the question. So finish your question.
Is there conduct that you have reviewed that shows to the contrary?
Yes.
Okay. And can you take us through how you've come to that opinion?
Yes. There's conduct by Tim that the tone is terrible. The tone is awful. And how he's talking to the child with that tone is bad. But what he is saying to the child isn't horrible. He's saying, I want you to get better. I want you to make right choices.
Sustained.
Your Honor, there's already in evidence. The jury watched the Ring videos.
Response.
I mean, we don't know which one she's referring to.
I remember one of the videos where that was said. So as to that particular comment, I'm going to allow it. You can continue answering it. Objection overruled.
Thank you. Go ahead, Dr. Rappa.
He was saying, I want better for you. People are going to not want to be your friend or be close to you if you continue to act this way. I want things different for you. And while his tone was bad, what was coming out of his mouth was not bad if he had been using a different tone.
The state talked about let me start with this. The state talked about the effect that the Ferriters' actions had. You're not disputing that what they did was wrong, right?
No.
Okay. So let's sort of take it back to that 2018 period. The state mentioned a number of different school emails or referrals that had sort of acts that had between 2018 and 2019. Is that fair to say?
Yes.
In cross-examination. They talked about stealing sprinkles, some fights that happened. Is that correct?
Yes.
First off, how does a psychologist separate what is regular childhood behavior from what is so concerning that it amounts to a disorder?
I think that what we look at is persistence. Is this happening over and over and over? Is it a pattern of behavior? And is this behavior not going away, even though school might be punishing or the parents might be punishing or giving consequences? The behavior continues to persist.
Do you see that as it relates to in the records in this case?
Yes.
Do you see that in this case, in the records as it relates to even prior to May of 2018 when Tracy got pregnant?
I'm going to overrule it because the answer's already been made of record, so it's really cumulative at this point.
You can answer this question and then I'll move on, Judge.
So yes.
Okay. The state mentioned that in your work, this is the first case that you've testified regarding malicious or allegations of bizarre punishment. Is that correct?
Yes.
Have you testified about early childhood trauma?
Yes.
How often?
Oh, my word.
Hundreds of thousands.
A high number. I mean, I've been doing this for 20-something years, and, I do trauma work, so a high number.
And when you are sort of hired, do you work for both the defense and the state?
I do.
If you had to put a percentage on it, how often are you working for the defense versus the state?
Right now, probably about 50-50.
And is that locally in South Florida and nationally?
It's throughout Florida.
And have you, in fact, been hired by this state attorney's office on a number of cases as it relates to childhood trauma?
Childhood trauma? I don't remember in specific childhood trauma, but I have been hired and enjoy working with them.
One moment, Your Honor. I don't have anything further.
Okay, thank you, Ms. Moran. All All right, ma'am, you just remain where you are. Ladies and gentlemen, it's about 12:20. We're going to go ahead and break for lunch for you folks. We'll start back at 1:30, so be outside at the elevators at 1:25 to meet with Mark, and he'll bring you to the jury room. Remember, you haven't heard it for 3 days, but I'll remind you, don't discuss the case with each other or with anyone else, do any kind of research at this point. Other than that, enjoy your lunch. All right, everyone may be seated. Let me have counsel approach you. Ma'am, can you come down here in front of the bench, please? Okay, so you guys can go back to your table. Before I let the attorneys go for lunch, go to the mic. Yeah. So the question I have is for the afternoon session, you have about 3 hours of.
My hope is to play the videos that I intend to play. I provided the state with a actual copy of the video. And just so the court knows, I understand the state's entitled to time to review it. I'm not, we'll deal with any objections. These are the videos that were in the 21,000. So these are not,
Okay.
these were in the state's possession.
Well, the 21,000 is already in evidence, right? I mean,
No.
what is in evidence? I thought it was.
The room. The state admitted videos only of inside the room, and then
But then we had a subset of that as well that was played, right?
Correct. So what was played is room. I would have a problem with my abilities with what they're entering in. On Sunday, they provided me a list of 3,000 videos. It's 50 hours.
But what's your legal objection? Because
So
if
I've already looked through some of them. Some of them are self-serving hearsay. They're saying things to the child victim in there. Some of them they keep out the part where they're like, there's a rule of completeness problem in the sense that there's an example in the 3,000 videos, there's a line of videos where the child is out in the living room playing with them, and then they delete the part where Miss Ferriter makes him go to his room and the other kids continue to play. So there's that problem, and that's all I could tell, like, after looking at it for a couple hours. There's also, there's one where they're just like praying, like that would be improper character evidence and inadmissible. And so I tried to look through the 3,000 videos that they sent me. They said that they intended to emit 50 hours of video, Your Honor. And so now, yesterday evening at 9:30 at night, they now are saying they want 14 hours. And so it has to be manageable for me to look at to see if there's an exception. Beyond that, the exhibit that they have provided does not indicate times or what file they're looking at. It's just a montage of videos without context, which I think is problematic and misleading to the jury. When the state admitted it, we admitted the actual videos with the times. And our composite exhibit has that as well. So it's problematic. I can't even check what they put in to make sure it's the correct order, the correct day, and the correct time, because they haven't given me the file names that are in what order.
So, Judge, I would like to respond to this because I think there's sort of a fundamental issue. Obviously, there are a lot of videos in this case, and each side is entitled to review anything before it goes in front of a jury. But this idea, I mean, that has unfortunately been the practice on both sides as it relates to the videos. I received their list of their 8-hour montage 7:30 the night before. And when I said, Judge, I think we have something here that we may not have been disclosed, the court said, figure it out or don't, or bring it to me.
Same thing I'm going to say now, figure it out. Here's what I'm going to do. You're going to play the videos. You make your contemporaneous objections at the time it's being played. You stand up, you object, and if I think there's inadmissible hearsay coming in, I'm going to order stop play immediately, hear the objection, and if I rule, if I sustain the objection, then you'll have to move on to the next video segment, or at least mute out the objectionable hearsay.
May I address?
Let me finish. I'm not so terribly moved by the lack of specific date and time of the videos, if the understanding is that these were all videos during the relevant time period from December 28th or so to January 28th. I mean, that may be, that's something that might go to the weight, but I don't think it goes necessarily to the admissibility.
But basically a foundation for, like, they're making assertions of the date that these are on.
But are these already in evidence?
No.
No, they have to be. You can't play them without them having been in.
The state advised me that they would not be objecting to the date and time. They're done by date, and then they're done in chronological order because the epoch time. So I called Lowe this morning. I confirmed with Ms. Coakley in front of Agent Lowe and Mr. Wahed, and I said, hey, he's testifying. You're not contesting this, right? As to the foundation of just the dates and the times. And she said, no, I'm not contesting that. I even emailed her over the weekend because there's some videos, as Agent Lowe testified, that aren't in the epoch time. They're in the 7505. How those times are determined. So I can call him back, but I don't know that that's reasonable because also there's zero dispute that these are from the time frame charged in the information because these are the only videos that exist that the state's had since February 3rd of 2022.
All right, so I'm obviously not going to permit the jury to see anything that's not in evidence. So we have to cross the threshold first of, is this going to be admitted into evidence? So is Ms. Murad correct that you told her that there was not going to be any authenticity type objection?
I'm not an unreasonable person, Your Honor. I am not. I agree that the videos and the date and times, what she has provided me is a 14-hour video that does not have, I can't confirm anything. I can't say that this is from that day. If she gives me the file names, or the video included the file names, so I could spot check them, I would stipulate to the date and time. What I have been provided is an hours-long montage of videos without any signposts as to what they are. That's my problem.
So the videos have the date, and then you see the videos from so it goes December 29th, video.
Where's the date? In the file name or in the video itself?
It's in the video itself, just like the state did.
And is that an accurate rendition of the
Yes,
the
Judge.
date and time?
There's no times. There's no times.
Just the date.
There's just the date, and then there's hours of video without any times, and then there's another date. And so that is my issue, is that I can't check it. I can't tell what was missed out because I haven't been provided that information to check.
So we did provide it's about 889 videos, which I know sounds like a ton, but again,
Let me ask you this. When you folks estimated this trial was originally going to take 5 days, and now we are on day 7 and looking like day 8 and possibly day 9, I mean, I put a lot of credence in attorneys' estimates of how long it takes to try a case, but this one seems like another universe in terms of the reality of where we actually are versus what was represented to the court as the amount of judicial time that was going to be necessary to be set aside. I guess what I'm getting at, has all this changed on the ground in terms of how much of this video is being presented? Or were you aware of this from the very beginning, that you intended to have 14 hours of video that you wanted to play to the jury?
I actually didn't. I didn't know. I knew the state was going to play some videos from inside the room. I didn't know they would amount to approximately 8 hours. Also, their witness was deposed pretty close in time to the trial and made the claim that this was solitary confinement. So
All right,
I didn't expect it to be this late.
Let me move on. Unless you're seriously contesting, Ms. Coakley, that you didn't advise the defense that, let me state it another way. If I accept Ms. Murad's representation that she was not aware there was going to be any authenticity objection, I'm going to allow the playing of the videos without prejudice to the other objections. But as long as there's a date on the video that shows it was during the relevant period, I'm not going to deny it coming into evidence as a result of it having a timestamp. Again, I think that goes to the weight as opposed to the admissibility. So I will allow that to be played, but I'm also going to require, Ms. Murad, that as you play these videos, you let the state know which video file you're playing so they can pull it up on their systems and do whatever they have to do. You need to move these documents in evidence, and so when I receive them in evidence, it's going to be a limited admission, because if there are specific objections to the content, like self-serving hearsay or some other basis for an objection, and if I sustain that objection, that's going to have to be redacted from the evidentiary portion that the jury would be entitled to review. So if you want to comment on what I've said, if the defense was led to believe there was going to be no authenticity objection, I'm inclined to let them pursue the way they want to, and not get so hung up on the lack of a timestamp where there is a date stamp on the video, and where there's no reasonable dispute that these were part of the video montage of what had occurred in his home during the relevant time.
Your Honor, I even told them that I would agree to the date and time. They have not provided me the date and time that they're offering to admit. And so then there's no way for the jury to have context. So that is the state's problem.
Well, she's saying the date is going to be on the video.
The date's going to be on there, and then we have no idea what time, if they're out of order or anything, because it's not contained. The way that the state did it is we provided what file name was before every single video that was provided.
So
It's 14 hours, and there's no way for me to check what was left out or not left out, because they gave it to me this morning. And so there also has to be like about what is cumulative evidence and what is like a reasonable amount of evidence for a jury to get. Just give them 14 hours without context.
I don't disagree with that, but the state did play a lot of the videos, and I certainly am not going to limit in any real way what the defense wants to show is what they believe is the rest of the story with respect to the videos. They're entitled to do that. But in the same vein, Ms. Murad, the state was very meticulous in telling you the date and the time, and even having the UTC or UPC explained as to how it translates into local time. Are you unable to tell them what the date and time of each video that's playing is?
First off, when the state provided it to us, it was all, I mean, that entire list that they.
I'm growing weary of this argument. Answer my question. Are you able to provide them with the date and time of each video that you're playing?
Not in the next hour and a half, but I can get pretty close. And we do have a list that we provided them of the videos used. So I can get started on it, and I can certainly provide that.
I mean, don't you think that's something that they would have reasonably been entitled to know the date and the time of the video you're playing?
The actual file name is indicative of the date and time.
You have the file name then of each video you're playing?
Yes, and we provided that to them. They initially got something bigger on accident, and then I corrected it.
So here's what you're going to do then. Prior to each playing of the video, you're going to provide them the file name of the video being played.
Okay.
And then they can track it through that. Okay, everybody clear on that?
And I can announce that on the record as it goes through.
You'll announce it on the record, but I'm going to explain to the jury what's going on with the presentation is after you move the videos into evidence.
Okay.
And my general overruling of the authenticity objection is without prejudice to, again, assert any other substantive objection by the state, which you'll have to do in real time as the video is being played. I know of no other way to do it efficiently than to do it while it's being played. Let me hear the objection. And how are you going to handle the playback on this, Ms. Moran?
What do you mean? So we can use the toggle and put it on?
So somebody's going to have to be there on the button that when the objection is made, you stop it until I hear the objection. Okay?
And I'll be mindful of that.
So how are you going to even know which one you're playing though? There's 14 hours.
So we have it on a software, so I should be able, through the software, to identify. I mean, it's going to take me a second, but that is what I will do during the lunch hour. And if there are issues, I will let Ms. Coakley know, but I don't anticipate there will.
So back to the larger question here. I keep hearing 14 hours of...
I'm not playing 14 hours.
So how much are you playing?
Just for the afternoon, Judge. I need to speak with my client about whether or not he wishes to testify. We'll do that conversation during lunch. So it's very likely defense may rest today.
Okay. All right. So that's how we're going to proceed. Ms. Murad, you're clear on the process. And Ms. Coakley, are you also clear on the process? I know you may not agree with the process that I'm implemented, but it's what I'm going to order in any event. I just want to make sure you're clear on it at this point.
Yeah, I mean, so the problem is there's going to be things going into evidence that are not going to be played. And
Well, that happened. That doesn't concern me because that happens all the time in criminal trials.
Sure, but I'm not going to have an opportunity to review them before they're put into evidence, and presumably the jury could see that.
Well, if all you're making is an authenticity objection.
No, like as to hearsay, as to.
To the substantive objections.
Right, like that. Like I understand.
All right, so let me. Both of you have. I won't say both, but a significant evidentiary issue has been created for the court in terms of how to manage this. Ms. Coakley is absolutely right that before she agrees to a carte blanche omnibus admission of all these videos into evidence. Normally, the practice is that the other side would have already reviewed what's being submitted into evidence, and there would be appropriate redactions in advance of the day of trial having it played. So how do you address that, Ms. Murad? Because it's a real logistical issue that's been created, and Ms. Coakley's absolutely right. If you're only going to play 3 hours, then that's what should come into evidence. If there's more, then I have to give her time to review and see if there are any other objections.
So the jury's probably not going to go out with any of this until tomorrow after 5. Let's say we rest today. Closings are 12 to 5. We have to do jury instructions. So then we could not admit the formal exhibit until the state has had an opportunity to review it. And I know that this isn't really a defense judge. It's more just my practice. This was the exact same situation we were in with me, and I trust the state. And
the state may not trust you, though. And I say time and again.
That's all right. I understand.
Just because one side doesn't object doesn't make it right when the other side, or wrong when the other side objects. All right, so here's how I'm going to handle it. I'm only going to admit into evidence what is actually going to be played to the jury this afternoon, because that way I will deal with any real-time contemporaneous objections to the substance of what is said. As for the remaining part of the videos, I'm going to instruct both sides to do what you have to do to review the remaining part that's not played to the jury, and if there are additional instructions or objections that are made, then I'm going to have to rule on them and make sure that they're redacted before that remainder that's not played to the jury today is made available to them once they go into the jury room for deliberation. So that's the best I can do in terms of handling what normally is resolved way before we ever get to the day of reckoning like we are here. And so that means more work for you, Ms. Coakley, but I'm giving you the opportunity to review what's not being played to the jury for your purpose of asserting any additional objections. And the only objection that I'm kind of moving past is the authenticity objection, and I think everybody understands the reason for that. Okay, so last thing before I let you go is jury instructions. We're going to have a conference today because if there's a reasonable chance the defense is going to rest today, then we would start tomorrow with closing arguments and have to have the jury instructions ready prior to that time. So think about that over lunch. I'll see everybody back here at 1:30 sharp. Proceed.
Yes, Your Honor.
Any developments on the evidentiary issues we discussed before the break?
So I was able to provide the state, and I don't know why my initial breakdown didn't have this. I was just sent an erroneous document. I have the date on all the videos underneath that date in order that are played in order. So the state has that now. To avoid confusion, I am just going to play not the full 14 hours, but the beginning of the video up to the end of the day without moving the timestamps around, because then the state has the exact order without me having to announce it.
So just 3 hours continuous from start to wherever you get to that mark?
Correct.
Okay.
That's the only way I can do it without creating an issue for the state. And then they have all the other videos, so if there's other objections to the full exhibit, we can handle that tomorrow.
Okay, all right, so same procedure then. What's being played today, I will receive that in evidence over an authenticity objection, but without prejudice to raise any substantive objections.
Yes.
In real time. As for the remainder, then we'll address that tomorrow as to whether there are any issues on that.
Yeah, I'll do my best, Your Honor. And so I do think that there is, I'll let Your Honor get a flavor for it. I do think that there is an objection about the needless presentation of cumulative evidence. When we're talking about hours and hours, I understand that the state put in substantial evidence that was direct evidence of the offense charged. This is all collateral evidence, and although I would agree that some of it is admissible and relevant, to have the jury sit for hours, some of them they're like watching a football game. And so we're going to watch the football game with the defense, with the defendant sitting there.
I mean, I will say, as the judge sitting up here, there's both a potential benefit to that and there's also a potential risk. So I'm not going to comment on how the pendulum will swing on that, but
I might have and one of them, literally, you can just see the child's head in the corner of the screen, and people are so it's just him sitting in the corner of the room at the dining room table. You can't see what's happening, and he's just sitting there. So
obviously I don't have a flavor yet.
Sure, but so I just want to let Your Honor know at some point I do think I'm going to make an objection about the needless presentation of cumulative evidence. The fact that he was there and out of the room, sure, relevant. Do we need to watch him there for 45 minutes of court time? That, I think, it becomes confused,
So all I would say on that is in looking at the way the state presented it, it was my feeling that the state was trying to set up a video excerpt of each single day during the relevant period.
Right, when every time there was an interaction, enter and exit, more or less, is what we presented.
All right, so that I'm going to stay with my procedure. You'll raise any substantive objections at the appropriate time. So what I will ask Ms. Murad is when we bring the jury in that you ask to move in the exhibit, and then I'm just going to say the exhibit's admitted over objection and without waiver of any substantive objections to be made, as stated in open court in that sidebar.
Yeah, I don't have objections to everything. I do think that there is some stuff that would be.
Yeah. Okay. Yeah. All right.
What exhibit am I on, if you don't mind?
Oh, you're on number 17. Does that comport with the Madam Clerk? Yeah. Okay. All right, Ms. Murad, you ready to continue?
Yes, Your Honor, thank you.
All right, now you can go ahead and bring them out. And when you are at the table, please use the mic, because I keep getting reminders to tell everyone to use the mic. All rise.
Jury entering.
All right, everyone may be seated. All right, ladies and gentlemen, we're still in the defendant's case. Ms. Murad, you ready to call our next witness, or where do we stand with things?
Yes, Your Honor. I'd like to admit into evidence defense exhibit 17.
All right. Court already notes the objections that have been made to that. The court is going to admit defense exhibit 17 in evidence over objection and without prejudice to the state, excuse me, to make whatever substantive objections that may need to be made in real time, and also for the reasons stated at sidebar. So with that, you may proceed, Ms. Murad.
Thank you, Your Honor.
Where? The one he's laying on right now? I heard him rubbing against it. Oh, really? Yeah. Button here, button there. Right here? Yeah. It's like an outside wall. So it's going to do this. He's going to pick this thing up. He's going to hear 3:30.
Oh, Ms. Murad, can we stop this?
Oh, where you at? Like 20 minutes.
My understanding was prior to each video clip, you were going to announce the date and the information necessary for the jury to put it in context.
Yes, Judge. I actually thought I said this prior to the jury coming in because the state has the list of it. It's just by date, which is already before each one.
Well, I don't know that I see that. Go back to the beginning, because I want to make sure that the jury has the date at least so that they're seeing. Okay, so that'll be the date that gives you the context for each of the video. And Ms. Murad, is that before each separate video clip? Okay, good enough.
Yes, I'm happy to announce that.
All right.
The one he's laying on right now? I heard him rubbing against it. Oh, really? Yeah. Button here, button there. Right here? Yeah. It's like an outside wall. So he's going to do this. He's going to pick this thing up. He's going to hear 3:30. Call to where you at? It's like 20 minutes. That's correct. Let me see if I might go on your hotel. Make sure the lights off in there. we're going to feel better. Okay. Yeah. You like that car? You know why? Yeah. The windows open closed. Yeah. You're not feeling good? No. So, no, because that's why I like, I can hold my cough down. I just feel weird. So, always opening down after you get done. Where, if you want an apple? Yeah. You want an apple? Yeah, didn't you say you wanted an apple? No. No. Okay, we're gonna go night-night if you're not gonna eat any food. Bananas are right over here. Banana? What? Yeah, what for you? You want a banana? You want one? No? You can go night-night?
December 30th of 2021.
When we get these boxes out, we'll adjust. Right now? I got it. Do I get something all attached to the pot? Can you do that? No, you can't. Is it okay for you here? No, the guy took it? Open it up. He checks. And he not only that, he swept it out, so it's like. What are you doing? Nothing. You want to see my what? Couch. So everybody might need a filling strip out later. Yeah, I think they earned it. You can run and get whatever you want. And Mama. You got You did the shopping? Yeah. Nice.
I was in my car. What's the car though? On my car.
It's weird seeing all that stuff. Outside on the left of the house. Good job, Mom. Yeah, actually, by the garbage on the left of the house. Put it inside the fence. Right, inside the fence. This carpet needs to be vacuumed, of course. Where's the fish right now? Okay. Is this the charge from Tucson Water and TEP? Yep, I paid it. These were all on the bottom there, so in case like anybody's dresser, these are all actually been falling out. There was one screw that fell out, I put it up on there. Put them there, because in case like we gotta build something, we don't have it. I found piercings. Good. Well, you might check, just before, and they're not going anywhere, but both pods for execution. I'm not taking all the paper out right now. I'm just gonna try and build his, but yeah, they're still. Yeah, well, there's no paper in any of it. That school box, is it in here or is it out? Just like the inside. Outside. Okay.
My desk bed is my room now. Move it to the side door.
See, got the water on?
No, I see Pierce over there, and the hose is right there.
Shut that door, I don't know it. Outside?
Yeah.
He's outside.
The water table?
Can I take a quick shower first?
No, Pierce, no, my time.
Yeah, we got that.
Yeah. I won't wait for you.
You wait for me outside?
Yeah. Wait for me later. I'll wait for you later.
Good boy.
Hey, I got, these were extra ones from me.
Where'd you go, Mississippi? Mississippi. Oh, yeah, they come out for one.
What do you do, Brad? Probably to stand here and just fill this whole thing up. All this, fill up this whole thing. I'm sure we're going to get started just to go with everything. I'm sure how you see the parent and all this will be the wash.
Here. You want ice cream? You want ice cream? Mama needs your help.
For the record, I'm going to skip to a later timestamp, and I'll put that on the record just
Okay.
so that we're not being redundant.
All right, thank you, Ms. Murad.
Thank you. So I'm going to time this. I just want to make sure it's accurate. I've started it back at 1:30:24. Now playing December 31st, 2021.
first time in the car, she was like super scared and hey, just don't lift her, just let
it's an opportunity for a lot of these young guys to make a name for themselves to get to this big ACC competition. This is not big for football to Aaron Young. As Luke Lasperson just about took to the little wobble, but I think they need to hear the voice down how risky this guy is. Right now, we have to take a look at it. The previous players are rolling on a fans deserve. Look at this place. Pristine beach, exotic wildlife. It's about time we got a real vacation. I'm 53, but in my mind, I'm still 35. That's why I take Osteobite.
And certainly he's playing at a championship level, but if his team's going to compete for championships in college football, it's the defensive side of the ball that needs to make a step.
They do, and both these teams actually, very interestingly, have lost their defensive coordinator. So both head coaches are going to be calling defenses in this game.
Without a touchdown, be playing in this stadium again.
Lying down on the top 3 letters.
They're going to say he's short of the one. Bonison with the tackle.
You see the weapons, right? We talk about what they're going to affect the game. Gore's at the 6-yard line. Now the ball 2 yards.
Receiver Donald Stewart. Abraham is covered. And wait for it. For the first time today.
That'll be funny. I had this type of lightning.
Guys are always kind of off on their own. On the sideline, where's that number? Oh, there you go.
Typically, you would think a punter that is that big of a weapon that can change the game. It is more punts shadowed. Back towards midfield, and Rutgers will get it. Great field position at their own Charlotte Knights. The ball back down 7.
I sit with the boys? Can I sit with the boys? Yeah?
It's your own helper.
Yeah.
Your SUV is a multi-purpose tool. Like a
So on SUV?
And every tire should be multi-purpose too. Like this tool, They're tough, but also run smooth as butter. And with two sidewalls, it's like having a multi-tool that can look like a completely different multi-tool. Don't take that idea, by the way. I'm going to patent it. Go with the Coopers. Cooper.
All right, here we go. Miller in motion. Wait, is that a baby on the field?
It looks like it, Chris.
And the defensive linemen are playing peekaboo. I've never seen anything like that before.
Hairstyle appears to be reversing the baby.
That's a great moment right there.
Chris goes to the rule book here.
Aaron is off to the races. We don't need it. One trip play. But we can all use more ways to say, are you kidding me? But it's going to be a long bus ride home for the defense. With this one, catch it. That's a throwing. I don't know, nothing. That's a wide open door. And he steps up. Mr. Everything Lincoln in the flat. It's been impressive. You know, it's been impressive watching what Sean Gleason, the offensive coordinator, has done in terms of prepping and game planning this week. 18-yard completion there, and after Lincoln makes the catch, he lines up his quarterback on his goal. Caught by he's inside the 25. 11, more on Washington. Let's go to Alyssa.
Guys, Isaiah Washington's one of those moments that I'm excited about playing in front of the family here in Jacksonville. Coach just said, phenomenal person, amazing size receivers as well. Coach Giano said they're trying to get better at being bigger at the receiver position. He also said he makes those like Odell Beckham type catches in practice. He's been working really hard to earn a starting role. Now being able to start in his hometown, pretty special.
It's a Trinity Christian High School here in town. Aaron Young has a touchdown run early in the game. He gets inside the 20 down to the 16. So Washington in the day to be the good receiver. And Young at running back replacing the starter Isaiah Pacheco. Both of those guys getting ready for the next level, and both have been terrific so far.
They really have. And every player on this Rutgers offense situation will do that. A lot of big play guys are not here. So let's play some small ball and we'll be really efficient at doing that. And that's what you're seeing. Getting Rankin involved, the run by Bedroll, and then Aaron Young, a little Gatsby run, getting vertical.
Bedroll fakes it to Young, keeps it. First down to the 12.
That's a Gatsby run. That's what they had. It's a 90% of their running yardage that's really between tackles. I think right out far is what Rick Giano wants. His personality is let's drive it to the right, down the field on the ground.
Start of the Knights in the first half. Here's the 2-minute mark. Now Ryan was breaking the tackle and might have gotten back to the line of scrimmage. Ryan Smith missed the original for the initial tackle. And now called the 5:58 left. 3-4, the first of the half. 30-second half. Right here, they're coming up. We'll have a wild direct drop halftime. We'll talk about that. They has dominating the whole season. And not even the regard of Joey Galloway. We'll have that for you. Where Red makes the tackle and it's another big timeout. There's something that happens 30 seconds in later. I didn't know which way you were going to go for that second game with the Dogs and the Wolverines both so physical at the line of scrimmage. Just to be for that.
Yeah, you look at Michigan defensively, they were so good. I decided with the good team. However,
I'm going to watch the football, okay?
offensively, I think what
Yeah, you call it how you see it.
really presented as a game manager, allowing him to feel comfortable with the people around him. We were Brock Bowers had a really good game.
Yeah.
11 touchdowns on the year.
Goes to the end zone and it's picked off. Intercepted by
customers on Sprint. Tell us more, Diane.
Customers on the Magenta app can trade up. Customers can also get a free year of Apple TV Plus. I know you love Ted Lasso, George.
Don't be a start. T-Mobile is bringing it all together for the holidays. Upgrade to the iPhone 13 Pro on us. Plus, get a free year of Apple TV Plus only at T-Mobile. On a suspicious fence by Dr. Pepper. Hi, Logan. What if you help me out with something? Sure. Looking for a couple of goalposts. Went missing after the big win last night.
What? That's awful. Who would steal a goalpost?
Hey, that is a nice new swing set you got there.
Oh, this old thing. Makes the boy happy, I guess.
Interesting design.
Yeah, it's Scandinavian. You know what? You should check the streakers across the street. They have a very suspicious new antenna.
Thanks for the tip. Anytime, Sheriff. Dr. Pepper, the one fans deserve.
In Arlington, crazy numbers, over 4,300 yards passing, 43 touchdowns on the season. Sensational young man that will represent that award so well for the rest of his life. Here, Claudia Haskins makes the catch from Johnny Lincoln, and he gets up near the 35-yard line. We haven't even seen Noah Vedral yet in the second half. We've seen other guys throwing a quarterback.
Look at a little sidearm. Manipulating arm angle. There's a little wrist swing in there. Good job working around the defender. Tell you what, just when you think you got Johnny Langan figured out, you got another little trick up his sleeve.
There's Vedral. Surprisingly, didn't start the second half, and Gavin wins it through the interception.
Yeah, I'm not a big fan of that. Get his confidence back before he was thrown. That's really just going to be the
The sideline on the second and 12. Just a little quick throw to Christmas Dribble. He gets up there to 37. And Luke Masterson, for 6 years, has been all over the football field.
Yeah, Luke Masterson, linebacker Nick Anderson, his protege and safety. Luke Masterson was a safety for his entire career. This year, he put on 10, 15 pounds, moved down to linebacker, was part of his work last year with the tutelage of Nick Anderson, who had a breakout performance. His first game is 9 tackles for Virginia, the second game ever, 3 interceptions for Virginia, second goal line.
He's trying to get up the field on the 3rd and 8. Vendo's got time, though. Can't get out of there. Shoestring tackle by Dion Bergen. He gets the second.
Bergen. Late.
Can you put that on pause for a sec? All right, let me have you approach. All right, so ladies and gentlemen, we're going to take a 10-minute break. We have a kind of a lengthy afternoon of videos being played, so I want to make sure that I keep you alert and just kind of break it up into no more than an hour segment at each time. So we're going to take a 10-minute break now for you to get back there, stretch your legs, clear your head, and we'll get back started back in about 10 minutes. All right, I've got 2:25 on the clock up here, so we'll be in recess until 2:35, 10 minutes.
Your Honor, for the record, I paused the video at timestamp 1:50:52.
All right, thank you, Ms. Moran.
Back in session. Yeah, I'm Judge Howard Coates presiding.
All right, you may be seated.
Could you check and see if they're in the hall right here? Thank you. Thank you.
Are they outside, Mark?
They're coming.
Sorry about that, Judge.
All right, Ms. Murad, you ready to proceed?
Yes, we are.
All right, Mark, you may bring the jurors out.
I'm sorry.
All rise.
Jury entering.
All right, everyone may be seated. Ms. Murad, you may continue.
We're restarting the video at timestamp 2:18:19. It's starting just a little before that, just based on how I can scroll. That's video for the state's record 164-09-86-17-6000 on Friday, December 31st, 2021, Eastern Time, 11:29 a.m.
TV, he'll do it. Yeah, 7th.
Trophy winner
fourth from Alabama since 2009, their first quarterback to win it. And he cemented his vote at the end of the year, led them back from 10 down late in the Iron Bowl against Auburn, a 97-yard drive. That was a touchdown pass, and then towards the final game, tremendous defense, championship game record,
400. You got two options yet. Just see what it looks like as far as the basketball is. Just don't know how you're gonna go look at always adjust. The other thing about this, it's quite good he puts this thing on the wall. Because we used to have picture frames up there. No, it's just nice having that house. Got that, you know. It's funny how Mary's just like play and sleep, play, sleep. The dog is like, hey, I'll sleep. Did you feed her yet?
No. They said they usually figure from like 5 to 6 days they would start to earlier, and then she went to sleep. So I got that switch of zero for 2 days. And she was like, somebody. That's why I got her this thing that they recommended, and I read all the reviews of it, and she has a heartbeat, just like puppies. They post competency at night. Because they feel like it can be other puppies and someone out there, super cute. They were really like, she really should have been playing.
He started playing for them in 2017. In his 53rd career game.
It's funny when Max got dead, he didn't care about them.
Max can big hit the box and listen. She'll be big. I think she'll be just probably more than that. Just more like.
Was taken to the turf by the Broncos. Back their leading tackler for the year. Cincinnati Fields is making it used extras a little bit.
Laying on that ball.
They went back to the line, but they got the play. They gave it to James Williams on the third.
One day of a lot of work. You can watch today. It's tomorrow running up. He took that. He took that shelf.
It's the calendar and shit. Yeah, it's been winter like 90 degrees. It took me a while to go there.
Take it back. What did you do with the
His biggest concern is
yeah, they should be there.
in the trenches. Bigger offensive defensive linemen that we've seen all year. Right now,
Yeah, we either did that or we're doing in the box again.
These guys are just driving. Glad selling already. Not a good start.
6'1", 225, averaging 89 yards per game. Darian Beavers made the tackle, another excellent linebacker for Cincinnati. Ninth play coming up, the first 8 of all their runs. Sanderson and Ryan. Marcus Brown, Dave across, and Dominic Sater. This is just his second career start. Sophomore, Georgia. Here's Steve Offside defense making contact. Second half of the Iron Bowl in place of Darian Dalton, starting center, and started against Georgia. Another tackle for Georgia and did very, very well. We're very confident in what he's been able to do in limited playing time. It's like Doug Marone, their offensive line coach last night, said, I love Central well, but I'm not worried about him. Cincinnati coaches, defensive coordinator Mike Tressel, they believe that's a matchup they have to win. Their great coach, Curtis Brooks, on the new center, Watley. Trey Sanders, number 2 running back. He's down to the 10, just shy of the first down.
So when you're looking at your run list, Alabama, I think they lost to 10. They got Harris. Alabama, they were very good at this schedule. Alabama is probably the best in the country. They win every game. Well, it depends on the day. I just play well. They are the best team, I think. So they play the SEC, so it's probably the toughest league. Cincinnati plays in okay.
Would it make so much tactical or have a balance between very good teams?
That's kind of what you're looking at right now. They play, I'm not going to say bad, but look what happened right now. First drive, and now that's switch. They go in. It's not expected. We'll see how they respond. This is one thing about Notre Dame is Notre Dame plays the toughest people every year. Yeah. So sometimes that's bad for you, right? Because the game. And in college, you can't really afford to lose more than one. Yep. The sad part about this is that you don't want it to be a blowout. It's a tricky thing. So let's see how our here come Bearcats. Let's see how the Bearcats respond.
Super tight right now. Super tight right now.
Okay, come on. Let's make sure we watch the ball.
The ultimate experience that offers multiple package options by single location.
Got a spot for you. Right here, stop right there. It's right here. We'll watch football. Sit with the boys. Yeah, come here. Sit next to me. Sit next to me. Next to me. Okay.
He's had not watch football. Kentucky, Cincinnati, FBS offer. Started. Now 49 games. He has 43 wins. Only Kellen Moore is on McCoy.
That's fine. That's all like uppers. Yeah. Especially here. Be careful.
Terry just wanted to tell you that she was watching you guys work and she's so tired. Mary. She was like, wow, you guys are a lot of work. I gotta take a nap.
Quarterback, but let's throw the ball down the field.
He's one of the shortest balls for ever.
Impact player, he is an impactful guy. Concerns in the secondary.
Second and 4. You're real sad if they don't get a first down. Yeah, I mean.
Mathis there for Alabama.
A beer? A beer? A beer? In about 19 years. You're on 2, right?
This afternoon, they are without Josh Joel, the 2-year quarterback, had foot surgery, turf toe, after they lost to Georgia. He's out for the year. This is the guy right here, Pierce, who is the guy that they like to throw the ball down the field. So he's excellent on contested catches down the field.
They got a first down.
Playing in place of Joe today. Straight
No, that's okay. Right, going ball and the fiesta ball. No, I'm dressed up. Sugar. What? Sugar balls. Sugar. Sugar ball never went. Yeah. It's in New Orleans. There's a cotton ball. It's going up. No, I was in.
Brian French
Yeah, that was
plays in the secondary, but he's
There's the orange ball. It's better than this one.
something to run stop. Good blitz here, and he's smart too. Because he wasn't going to get to Ritter, but he had eyes on the quarterback, and he knocked that ball down. I also play some quarterback today. Nick Golden just saw him to go told us that they're
Take her juice. She just wake up. You're a whole guy now. Okay, I'll take her outside. Just sit there. Oh yeah, I saw those usually. Wow, that's impressive. This is also a playoff. So the winner goes on to the championship. Who plays that second, third? I don't care about second. Just the first. Yeah. Alright, so orange is Florida, rose is LA, Pasadena. This is Cal. Where's the sugar? I just told you.
college football playoffs semifinal.
With it easy?
Possibilities. Good year. Ford
Texas. Oklahoma.
Fast, reliable, and secure. Taco Bell.
New Orleans.
And Allstate. Serve money like a champion.
Why they call it Big Easy?
Some outstanding non-Power 5 teams.
But
Recent years of college football, none of them.
I appreciate time with Florida. Fiesta though. Let's stay in the Fiesta Bowl. There, this one. I'm ready to get going with a second chance. Better get this right where you get sleep. Not Saturday. Here's it. Alright, good job. Fiesta. We want this to be something.
Alabama, timeout. He had years open on the slant. He had beaten history right away. And the ball, the second time, the ball is not.
Hey, girls.
The slam. He's got
Mary's up.
right off the snap. Boom. He's wide open. The ball is knocked down the line of scrimmage, and they tell him foul.
Okay.
Well, that would have been a touchdown for the Bearcats.
Mary's away. She's out there going boogie.
Second and goal.
Oh, got his hands.
Here's the history again in coverage. First two plays inside the 10, they throw the football.
He should have caught that. That was awesome. Here.
A blowout.
Or you can leave it here.
Weakness for six.
We'll start looking it out.
This year they've tried three different kickers.
Hey, we're gonna go in here so I can get her food ready.
Here goes Cedric.
No, hey.
How you doing, Owen? Great. Super excited to be on this.
Entertaining stuff to watch you. Well, the season finale of Fayetteville, right under Pepper. Steve
season in it.
Yeah, I felt like we lived in some fictional town with sort of some elaborate marketing.
But what did it even be for? Dr. Pepper?
From Papa John's.
Hey,
And Alabama.
he's trying to just like go over, let her go. You let Ava get that much secret and I want her. Hey, be nice, pet her. Pet her. You just pet her. Let her walk around now. Okay.
California.
Let's talk. You can help me get the food. Shit. You can help me, I know. You can't grab her like that. No? Give her a night-night.
You can hold her.
Yeah, but you just grab her neck. So he's no longer trying to hold her, so he's trying to fight her. He's tired, yeah, but you need to be nice. Hello, Patty.
That's a big development here. You see the patching around the hip.
Lay down there.
That's an electric stiff gear of some sort too. I saw trainers adjusting. Just comfortable.
Yes, two.
One pass on the opening touchdown. Set up and then Terry and Beavers. These two inside linebackers have got to be back. Beavers is an NFL caliber guy, 6'4", 260 pounds. Jordan Longo, they're both 60 seniors. They're veteran guys.
I'm going to scroll forward to timestamp 2:41:50, which is video number 164-098-779-1000, and the date and time is December the 31st, and the time in Eastern. One moment, please. Sorry. (11:56 a.m.)
We were gonna do history volleyball. Ooh, face mask. Watch flag coming. Wow, no face mask. Nice sack. Let's see your play that.
This actually worked out great. They got more lost yardage on
The flag has to be called when they see it, right? You can't replay it and then call the flag. Well, make it out. Leave this door.
I'm now moving to timestamp 3:22:33. That's Saturday, January 1st, 2022 at 8:56 a.m. Eastern. The relevant video number is 164-105-98-1700.
Going crazy.
An interconnected world. Every piece of information is critical.
You need approach? All right, Ms. Murad, you have an announcement to make?
Yes, Your Honor. We'll strike the file number that we previously stated as to this video, and I will place it on the record as soon as we make sure that we have a correct one. It is still on January 1st, and we just need to confirm the time. Thank you.
Noted.
This is a Christmas commercial. It's
Done.
Alright.
Welcome to Sonic.
This is the commercial very similar.
Feedback? Nothing cheese. Order up. Sonic
Here you go.
I know. Wait, what's wrong with Dave? He was like jumping on top of the Come on, Dave. Jump that hole. Yay! Good.
No.
Good. I'm going. Here. You pulled it out.
How'd they do?
How do you get it?
Put the leashes back where they were on. Do they need water out there, guys?
No. They have a bowl up there.
Okay, good. How far did you go?
We went all the way to the park and did the movie.
All the way to the park?
Yeah.
Oh, good luck.
Go sit over there. Go sit at the table. Go sit at the table. But you're actually to have full penetration. Go sit at the table. Shop Mattress Firm's here. Delivered fast. Only Mattress Firm.
February
Walk in and walk out.
Yeah, I cleaned it all up.
This is the last time we're all
There's picture frame.
What?
Yeah. Really counted. I would change my kid, but I'm going to deal with the fact that I got videos from guys around here. Let's go Rose Bowl game presented by Capital One Veterans. Herbie's calling it. Don't take your Bears already picked Ohio State. I'm concerned with the wide out. I know they're talented, but they're youthful. They're inexperienced. They don't have a lot of playing experience. So I got to go with Utah. I think it means a lot to them. Out the game with Utah. I'm going with Utah.
And they just did this show yesterday morning in Miami.
I think
It's kind of played last night. They did this morning at the Rose Bowl.
the physicality.
That's a bucket list there, Rose Bowl game on New Year's Day.
It's a last second field goal.
There you go.
First show of 2022 right now. The sports don't make a head-year pick from Miami. Oh, wow.
softball.
Their folks take on the Fighting Irish. What a stage. Marcus Freeman takes the reins. At Notre Dame, Coach Gundy said, Oklahoma State and the Irish first team. Spencer Sanders trying to bounce back from a tough performance in the Big 12. All-American linebacker Malcolm Rodriguez. It's the They have a new head coach, someone they're obviously very familiar with. A new era for Marcus Freeman and this program under previous head coach Brian Kelly. Notre Dame answered the question, can you get back to being a top 5 program? Yes. Now Notre Dame has begged Marcus Freeman to take them back to being the best program.
First game as coach.
He has been outspoken. For him to be whether or not Marcus Freeman was a top decision in the locker room when he was announced. Here it is.
Watch, these guys are pumped when they found out it's him. This is kind of inspiring. They're super excited he's their coach. Because he used to be their defensive coordinator. They go home and he was so good. So the players are happy.
The choice. And Chris Budd, you spoke with some of those players this week, their reactions to their new.
Of his entire life. Before the school announced the decision, Athletic Director Jack Sparrow brought all the captains together. He wanted to know what they wanted out of their next leader. Myron Tagovailoa of the one of the first things we had in mind was we wanted someone in-house to take over. In the short amount of time Coach Freeman has been here, he's cultivated that relationship every day. We want to see someone who genuinely appreciates you being there. We want to root for them. We're really for Coach Freeman. The guy I talked with, Coach Freeman, last night. Too much excitement, too much nerves. Maybe his first game as a head coach.
Well, plenty of emotion for Oklahoma State to deal with as well. They had a terrific season. 11 with Bedlam for the first time since 2014, and in the Big 12
Cowboys.
Big team this close to possibly a trip to the college football
Oh, that's
playoff.
right.
When you're that close to winning your league, Dan, how about the emotions now having to rewrite and get ready for this PlayStation Festival?
Football is a very good unit. They've got a ball control, balanced offense. They've got suffocating defense on the defense, and all of college. It's a good matchup for Notre Dame today.
And here come the Bucks.
Glendale, Arizona. Many softball fields. Small deer everywhere. You see all these cowboys and Fighting Irish?
I'm now playing timestamp 5:50:13. That's associated with, is that correct? Video number 1641164700500, and that is at 6:06 p.m. on January 2nd.
Together, okay? We'll go first.
His noodles are out there somewhere.
Yes.
There's no better time than now. Don't wear
So you can grab a plate, your plate's over there. I'll leave this up kind of here because
Oh, the girl can wash her hands. Sauce in your noodles?
Approach. Objection sustained. You may continue, Ms. Murad, in accordance with the court's ruling at sidebar.
I'm now going to go to timestamp 9:53:58, video number 1641419003000. That's Wednesday, January 5th at 4:43 p.m.
Bouncing off people. I told him, maybe look like a 25-year-old. He finished that. He's passing, right? Everybody thinks he's sat here and everybody just goes You're supposed to see how many touchdowns get thrown on 3 plays. Play game. Let's go outside. It's got to be 20 at least, right? Yeah, I think with the offside and 12 on the field for over 20, I think I heard that a couple years ago. Nobody touched it. I've been wrong. Have you ever been wrong, though? Have you ever done that and it is wrong to tell?
If you start, you like start to take up on that gonna do? You don't need to be there at 7:30 if you want to wait a couple minutes. Yeah, she's lucky today.
How you doing?
Good. Stay right there.
Yes, thank you.
Your pencil, right?
Yeah. I got a conference call at 9 video. So I have to go for the Dropbox.
But you don't want to things that take us like, I don't need to be there by 9. So I don't know, I'm gonna make sure everybody's in the car. Usually do not have to, but if the other thing takes long, then. So are you good? We'll be back. Later. Ready to do? Then you're staying at date. Back to you on Friday. Cool. Back to you Friday? Yeah. Are we gonna do the park? Maybe get your snack to come down. You walk back and then you can just go to the park. Go to the park. What are you doing?
I'm looking for one. Yeah.
Okay. Big exciting day. Teenager in the house. I'm gonna get a picture of you while you're going over here.
You know that I call myself on here. You know that I call myself. Oh, that's not okay. Remember giving me a big pack pencil every time I put a picture. I just remember that.
Did you wash your face this morning? Were you washing your face?
Yeah.
Alright.
Thank you.
Okay, great. Yeah, come here.
Well, I don't want a uniform.
That's great. I'll get you another one later. Okay. Right now. Come here.
You didn't help me walk.
Maybe you can hold this.
Okay.
What happened? What happened? What happened? She jumped on you?
Yeah.
Okay, yeah, she wants to play. That's why you gotta give her a toy, or you're not, can't like go and, if she wants to play, you gotta let her play. Yeah, she's a puppy. Where'd she jump, right there?
Yeah.
Okay. Okay, she's a puppy. Okay, now she's tired. She did one jump and now she's tired. Good? You want to do this muffin?
No.
You just have a smoothie? Let's just sit right here, Mike. Okay. So remember, she's a puppy, right? She's little. So she wants to play a lot. She wants to bite a little bit. So you gotta give her toys. Okay? And when she's just laying there, just let her lay there. Okay? You want your smoothie?
Now playing 112112. The file number that it starts on is 164 159 120 2000, January 7th at 4:33 p.m. EST.
You don't need them?
I just need like 2. Maybe 3. Yep.
I'm gonna help you with your lunch.
Here's your lunch is there. Is this the charger that came with it?
Yep. You know how charging it is?
It doesn't have to just take a look, right?
Want you to pay?
That's an engage. That should be good.
Okay. And then you need the stuff that's on there, right?
Yeah.
Want you to pay?
Oh, I'm gonna get ready for school.
You want to pay?
Do you like this one? Do you like it?
Yeah.
Yeah. Who's that?
Okay, ready?
Yes.
You got your stuff?
Yes.
Okay.
What? Can you pay card?
You can bring your cards in the car.
What? Can you pay in the car? In the car?
Bring your cards here. Go get a couple.
Apple?
Get some.
I got this. I only got this.
You already got 3.
Yeah, I only got this, Mama. I only got
That's a good idea.
3 cards.
That's a good idea. Yeah, Britnell is the best. That's a good idea.
I got 1, 2, 2.
3 is a great number to bring.
Mama, I asked what time he woke up at, and he said, time, 40 time.
Yeah?
Yeah.
6, right? You did a good job sleeping today.
I got this sleeping today.
You did a great job.
Does it
I got this sleeping today.
You did great sleeping today?
Yeah.
Did you bring your airplane too?
Fun. What are you doing?
Yeah. Your airplane?
Yeah.
Alright, so you've got all your stuff?
Yes.
You got your lunch?
Yes.
Just wait to look here. Leave her. We gotta go. Okay, so let's go out the back. Go to the back door and walk to that gate.
I'm going back to the college.
You have your shoes on?
Yeah.
Yeah. Yeah. Good, I'll just sit down.
Fun. You pay outside the down?
Why don't you go out the front? Sure, you go say hi. You go say hi to him.
You said she needed it by Monday. No. Something like that. She said she needed to fill that out.
Say hi to out front.
I'm
I'll start making you some noodles. Good. What's getting you is we got like the outdoor table sitting there, relaxing. We got the workspace. Say hi, girls. Right, take your items off the floor too, so make sure to take your shoes off, especially if they're like been wet and then sweep up the mulch and try to get it so it is not all over.
Can you do it down?
Later.
Can you do it down?
Mary is tired. She's tired, pup.
you want to go in the front? Can I go out there? Yeah, we can put it in. Sure, you want to know? Yeah, top. On top. What? Top too? No, it goes on top in the dishwasher. No, he's asking me if he can ask me. I said, we're just saying it goes on top of the dishwasher. Okay. That's what I'm gonna make you tonight. I got you the dinosaur chicken nuggets that you like. Dinosaur chicken nuggets? Yeah. For you, I can cook them. And then I got you dip. I got you the dip. Dip? Yes, you can dip them in. How's it going? Yes. Yeah, I'm responsible. Need a dip here for those? How's it going here? Great. I'm pretty small. Yeah. But not too small. Yeah. Wait, would you ever get trapped here? What is that? Oh my god! Oh my gosh! I think that's a long time. Oh my god. She's smelling hot. Oh my god. What? How's it? Mom, can I open this? I saw this in my room. That is, oh, this is bed frame. It's just open. Yellow. Or what? Over here? you want to go? Come back. Yeah. Wait for the time. Wait for the. How is it my bike?
This is waiting for his bike. Yeah, okay, your bike? You like your bike?
Oh, you.
Where's Mama going?
And Dad's gonna move that car.
Oh yeah, she moved the car.
Yeah.
The garage.
Why?
Well,
You want your red one, your scooter? I want that one. What's your mama say? Your bike? The girls? Want to come here? Dad's asking me. Can I put it back? Like your thingy. I crashed it last time. Need help? Which one do you want? That one. Okay, we'll just get this. Scooter was just
you can do it. You can do it.
Yes. Thank you. Volleyball. Yeah.
We got a horse here, we got a skateboard. Got a couple of skateboards.
All right, Ms. Murad, can you put it on pause? We're going to take a 10-minute break. It's 3:40. We'll be in recess until 10 minutes to 4. All right, everyone may be seated. Court will be in recess for 10 minutes. Back in. Yes. All right. Mark, you can go ahead and bring the jurors in. And as soon as the jury comes in, Ms. Murad, you can proceed with the continued publishing. Thank you. All rise.
Jury entering.
All right, everyone may be seated. Ms. Murad, you may continue your publishing.
Thank you, Your Honor. Now playing timestamp 12/15/16. That's from January 9th. The relevant video number is 705-1334-228-375-837-684.
this, okay?
Okay. Mine, can you go in there, Mom?
Sure, get in there.
I'll get in there with you.
Okay.
Oh, thank you. Ow, that
Okay, no. This is all for church. We're going to church right now. Let's go.
Oh, don't need
I gotta go get my shoes. Hold on. I go put this in, I go get shoes.
In the box. Bye. Hi. Oh. One ultra. Ultra. But ultra.
Yeah.
Oh, that was bad. I know what to die.
Who's your phone?
No.
It's our ball. Want to play it, please?
Yeah.
$10.
Yeah, no.
Thank you. Let's go now. Ready? We'll get more. Like your hand? Yeah, leave.
Are you here, that kid? I got you. I got you. Look that kid.
I broke the tree.
Dad.
Why?
Can the kid couldn't gonna fall down?
No. You get it? You give it the pound?
I'm gonna give it the old wife.
Oh, mega boom. Ready? Watch it. Ready? Watch. This is a mega throw, okay?
Yeah.
Want to see the mega throw?
Oh, on that car.
Go hard. Oh, almost a mega hit. You almost got mega hit. How do you put that tree?
Leave the flag.
You can take out the flag before we know.
Okay.
Here, it's by the top of the box.
Hey kids, how are you?
Good, how are you?
Good.
It's right there, okay? Yeah. Oh.
When it's a little face. says, are there 16 numbers or we're just out here at some point. She still doesn't want to walk out. Kind of like, oh, look at that fish.
Where'd you go?
Oh, she's down the stick on my mommy's side. Oh, and she's having here. Okay. Bye. Mama's coming home soon. What?
I have to need to do homework on my Google Classroom. I have to do IXL. You gotta be kidding.
I did too.
It's so annoying.
I got lucky. My English teacher was having to do Excel the first semester, and I missed it. So
IXL is so annoying.
it is. I haven't done that in a while. Hopefully, I don't have to do 2 hours.
I have to go to 100%. You know that?
I did too.
Yeah.
Yeah.
Uh-oh. I'll say right from
I
mine.
like fun trying to do better.
Make that by electrical box.
You guys watching this?
76, yeah.
No, I'm not you. No, you. You better catch that.
Yeah. Why?
Now playing timestamp 12/46/19, January 16th. File number, the starting file number is 705-380-6-007-824-489-460.
Once you get in your spot, okay? You can start doing it on your own?
Yeah.
Okay, take your backpack off.
You're ready?
What?
Are you ready?
No, I do it.
Okay, then that's fine, but you gotta get up in your seat.
I can put yourself.
Okay, put yourself.
Help.
Right, open the door.
That's it.
Alright.
I went to the yard so long, I thought that I was one time. And I woke up. It must like
Turn around, or else Father can do it. Turn around.
now playing timestamp 12:55:04, video number 164-235-316-8000. That is from January 16th, and I will get the court a time in just one moment. January 16th, 2022, 12:48 p.m. Eastern Time. Now playing timestamp 13:12:01 from January 18th. It begins at file number 705-466-275-931-0760-948.
So I was going to ask you.
Your current estimated got that. So we found there was like free stuff.
What?
So there was free stuff. So we just got a scooter, which is maybe it's a length scooter, and then we did a softball at this place.
That looks good. There you go.
So to see that works, you want to try it out, Ron?
How'd the presentation go? Good.
Where's the tire?
Okay. See if you put the tire back on. Did you just buy that one?
Here, want to try this?
Sorry.
I'm going to do returns at Walmart right now. It's 15. Well, there was just free, and I figured all some of them were broken. They didn't go down, and no, I told her I could spray it down if you want to.
This?
If you want it. I can do it.
Maybe get almond.
Did you just go hang out tomorrow? Somewhere new?
She said she's going to go back on soccer.
Yeah? Soccer? Very much.
Hi.
How'd you break it? Yeah.
I break it.
Want to try this one? You try this? This is Hot Wheels. Want to try it?
Yeah. It's hot.
Hot Wheels. Yeah.
Can you do small?
Do what? Bring down?
Yeah.
Oh, that's good for you. No, that's good for you. Go ahead and go try it. So, yeah, he emailed me saying some of the girls had said, oh, earning this week, coming today.
Did you
But the other, yeah. The other code. I'll come back. Yeah. Sorry. I was actually going to on earlier. I don't do that. I don't do that. I do. Look at that, I can't go. You said Maddie can't do it tonight. I'm gonna do that one. Fine. I'm gonna do that one. But time to make more.
Oh, yeah. Good for you. Whoa.
Fine. Oh, what's that?
Here, come here, let me fix it. It looks like it's curving with the... I told her we want her to do so instead of texting
Together we walk you out. Looks like
texting together, a phone call. She sat with us this is when we get in school. That's for text. All the sounds. Get a phone call.
I'm kind of surprised that she still does say that other one that she can do too.
Fine. I want to do that one. I want to do that one. That helps you? That helps you?
Let's not take everything out of there.
That helps, Owen. Come on, I'll do it.
Oh, no, I'm trying to fix your bike. Your scooter. Whatever you call it, Mr. Spoon. What's that?
I'm going to walk now.
No, I'm just going to look at you right now. Ready?
Be nice.
Outside. Can I help you?
Yeah.
Wow. Help me. And I help you. And I help.
Good job, dear.
But it's only talking.
Yeah, I'm on hold.
No, I'm trying to fix it. You want me to fix it?
What you have? Here, Fleming, give this ball to your softball.
Or do they just come off the driveway and it
Why do you move that part? Move that part up over there. No, don't throw it. Babe. Because I hear my face. And then just go to the front, get your backpack out of there. I'm out of here.
Now playing timestamp 13:46:17. That is 164-254-413-4000 on January 18th, 2022, and I will put the time on the record in a moment.
No, it's not okay. Yeah, I'm gonna do it, right?
This is at 5:15 p.m. Eastern on January 18th, 2022.
Right now? Good.
playing January 23rd, 2022.
Maybe those ones are these books, right? Yeah. Have you go and eat?
I like the scooter here. Oh, I kind of. Yeah, I'm not wearing big stuff. Right. Thank you.
Coming in?
Lock your door. Does it keep it for that? There's, oh, let me not do it. No,
Yeah. Oh, you hit football?
Yeah. Stay right there, Baba. Give me that. Stay there. Stand still. Oh.
Okay. That's it. Come here. Okay.
Feel the ball run?
Yeah, your deputy. Deputy, come away. We can throw this in, just raise a little bit. We can throw this in, you got me take her.
I could do. But only I'm not in this song. I'm gonna talk to that song.
Yeah, go get your bat. Go get your bat in the backyard. Here, go this way.
That way? That way?
Yeah. Go in the backyard, go get your bat. Yeah. Whatever you're concentrating on right now, right? Okay.
How long is that video?
Less than 5 minutes.
Okay.
Playing timestamp 4:16:53.
I hold in. I hold in. I hold in. The whole Megan too.
Yep.
Go up here. I'm holding here.
Oh, you don't want this drive? You want to bring it?
Just fill it up real quick.
Here, thank you.
I'll take it.
The pin should be in there.
Can I keep the TV on?
Ah, yeah.
That's my food.
It's my turn off.
Are you going to do the ball?
Yeah, fill it up.
Go that?
Yeah.
You know that the TV uses more, not the TV, the TV remote actually uses more energy than the TV itself.
It's easier if you lick it and you put it.
No, hold on. May I put this here?
Yeah, you can put it in here. That's stuff for you guys. Snacks.
Wait, we're bringing balls?
Make sure you put the pin back, alright?
Why are we're bringing balls?
The break soccer ball.
We're gonna play. You want to play and stuff.
Any soccer ball?
You come up there, the little
You gonna take your scooter or you gonna take Abe?
Okay.
You take your scooter?
Yeah.
I can do the R one. Can you do the R one?
Yeah.
Can you do the R one?
Yeah. 한국무슨 한국무슨 here. 한국무슨. We're going to
I don't know. Just having a night.
I'm gonna bring this boy.
You want to bring a basketball pumped up? You can bring it and play basketball. Okay. You bring yours from.
And finally playing 14:23:38, which will be about a minute, and then that will conclude the publishing of Defense Exhibit 17.
I was going to, then
I'm gonna put the leashes here, okay?
I was going to do it after the homework, but the homework was way too long.
Here, Scarlett, what are you doing?
And I could do it right now. I'll do it then.
No, they got some stuff from John over there on the side. Hey, car. Okay, here you go.
No.
It's just for you. If you want to, right now, go do whatever it is. Just one little sprint or something, whatever you want to do, or don't, and just do your shower.
That concludes the publishing of portions of Defense Exhibit 17. And Judge, we're also admitting, well, I can wait for a moment. We have Defense Exhibit 18 by agreement. We're just putting that together, but I think there'll be a stipulation.
Yeah, I don't have an objection to.
I think we're going to do this, but let's just wait until.
Okay, I don't have an objection to those 1 or 3 videos. I just need from the rest of the timestamp, which I think we're in agreement for.
For Exhibit 18?
Yes.
Okay, so is 18 being requested to be admitted in evidence without objection?
I have no objection, Your Honor.
Thank you.
All right, so the court receives and accepts Defense's Exhibit 18 in evidence without objection.
Thank you.
All right. Let me have counsel approach, please. All right, so ladies and gentlemen, the state is still in their portion of the case. I expect that tomorrow we will conclude the defense case and move into closing arguments and quite possibly deliberations to begin tomorrow. If you'll recall, I told you that the schedule for Wednesday is going to be a little bit different. Originally was going to have you here at noontime, but because there's some work that needs to be done by the court outside of the presence of the jury, I'm going to have you here at 1 o'clock so as to consume as little of your time as possible with us dealing with what we have to do prior to the closing arguments beginning and ultimately your deliberation. So with that, I'm going to go ahead and release you for the day. I'll see you tomorrow. Check in with the jury office at, I'm getting a little bit of feedback here. Check in with the jury office, I would say no later than 12:15. Be up here at 12:45 at the elevators to meet with Mark, and he'll bring you into the jury room for anticipated 1 o'clock start time. I expect that we'll go tomorrow until 5, and then if we're done, we're done. If not, then we'll go back to the Thursday 9 o'clock schedule. Okay? All right, everyone, have a good evening. Go home, get some rest, good dinner, and I'll see you tomorrow. All right, everyone may be seated. All right, Mr. Ferriter, rather than have the defense advise the court as to whether it rests today, I'm giving you the opportunity over the evening to think about one of those 3 decisions I had told you a while back that the defendant and the defendant alone has to make the decision of in regard to a criminal proceeding. And you've made the decision about the plea of not guilty, the decision to proceed with trial. So the next decision point that you will need to make will be the decision whether to testify on your own behalf or not. I'm going to give you the evening to speak with your attorneys and let them explain to you the potential risk and consequences of all that. I will engage with you tomorrow in a colloquy to make sure that whatever decision you make is being made by you knowingly and intelligently, freely, and voluntarily. So I'm going to give you the evening to think about it. I'm sure it's a big decision for you, and you can ponder on it between now and tomorrow. I do want the attorneys to be present at noontime for noontime sharp start time for us. I intend to address the jury instructions. I also intend to be advised at that time as to whether Mr. Ferriter is choosing to testify or not. If he, either way, I will conduct the necessary colloquy as I just indicated. Have we made any progress on the jury instructions? Because I much prefer that when you come tomorrow at 12, that we have as close to a final working set as possible, because my anticipation is that we'll go almost, if the defendant testifies, it'll be a little bit of a delay. But if he doesn't testify, we'll go right into closings. And so we're going to need a set of instructions as close to final as possible. We've got 9 jurors in the box, 10, 11, 12. Need 13 copies of what hopefully will be a final set. Are there any issues that maybe I can help out now to expedite getting to a final set as quickly as possible for noontime tomorrow? Because we have a little bit of time, and I'd much prefer to come with as close to a final set as possible.
Your Honor, the only thing I could think of is for weighing the evidence, I could go ahead and change that. I know that we usually have 6 through 10. Some of them won't apply here. Also,
Mr. Wahid mentioned something about a lesser. Has that been worked out between the two of you yet?
so, Your Honor, I think that this will be something that we will have to litigate as far as the affirmative defense for the aggravated child abuse and for child abuse. I don't know if we can actually.
What's the standard? We're dealing with a standard instruction on the defense, right?
Yes, but that is only given once they have proved by preponderance of the evidence certain elements.
Okay, and what are those elements?
So it said if burden of persuasion is on the defendant, if you find the defendant proved by a preponderance of the evidence that he was a parent of RTF and that he imposed reasonable physical discipline on RTF for misbehavior under the circumstances, you should find him not guilty. If the defendant did not prove by preponderance of the evidence that he was a parent of RTF, or if the defendant did not prove that he imposed reasonable physical discipline on RTF for misbehavior under the circumstances, you should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt.
So that's the instruction. Hold on, Mr. Wade. That's the instruction?
Yes, and then there is one that says if the burden of persuasion is on the state, if you find that the state has proven beyond a reasonable doubt that the defendant was not a parent of RTF, or if you find that the state proved beyond a reasonable doubt that the defendant's physical discipline of RTF was not reasonable for misbehavior under the circumstances, you should find him guilty of all the elements of the charge. You should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt.
So what is the issue on that instruction with the state? Because it sounds reasonable enough to me just listening to it.
The issue is with I don't think that the defense has proven by preponderance of the evidence that he has imposed reasonable physical discipline on RTF for misbehavior under the circumstances. So the whole point of the affirmative defense is saying that, okay, well, this is okay because I was imposing reasonable, punishment on the child. There has been no evidence presented by the defendant that he had
But
done
who's
that.
to determine what the defense has proven by preponderance of the evidence? It's in the jury instruction, so isn't that a jury decision? I mean, it's not the court, right? I mean, ultimately, it's not going to be an issue that he's a parent of the child. So the question is going to turn on the reasonableness of the punishment or not to the circumstances. And if that's to be proven by the defense to the standard of preponderance of the evidence, what I'm asking you is that a determination that the court makes before it goes to the jury, or is that something that goes to the jury and they determine as part of their instructions on the law that the state the defense has to meet the burden of establishing that defense by a preponderance of the evidence?
Your Honor, can you give me 1 second?
Yeah, do you want to go ahead, Mr. Weed? Let me hear your position on that.
Yes. So it's like self-defense. It's the defense raises it. If once the defense raises it, then the jury has that to decide. It isn't up to the court to decide. What the court has to determine, I believe, in this particular jury instruction, just by reading 16.1, and it's duplicated in 16.3, which is the lesser, if the court gives the lesser. And it's a question of whether or not the defense has both the burden of raising it in the first place as well as the burden of persuasion versus whether...
But by what legal standard? Preponderance of the evidence?
It's preponderance both times. So if I'm just going to go to the state's version that's already printed out in front of me. So it can, the first part of the instruction on affirmative defense is it is not a crime for a parent who is acting, the parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury may have resulted from the discipline. Part 2 of that is, and then it depends on whether if the burden of persuasion is on the defendant or on the state. And the instruction gives both options.
So what does the law say on where the burden of persuasion rests? Do you have case law to support your position on that?
So interestingly, the instruction that's here, so some years back it was an immunity issue. The parents had immunity on this. And then the legislature changed it, and I believe it was in 96. There's a case, I think it's 2002, Radford versus State. I don't have the site off my head, but it's a Florida Supreme Court case, actually out of an appeal from the 4th. And in that case, it essentially came down to what turned into this instruction. And the case wasn't clear on who had the burden, so the instruction has both here. And it heads it by saying, if the burden of persuasion is on the defendant, and then there's a paragraph, and then the next one says, if the burden of persuasion is on the state, and then there's a paragraph.
So this is not the first rodeo on an aggravated child abuse case, and I assume it's not the first time this defense has been raised by defense counsel. So you're telling me there's no case that tells the court which part of the instruction should be read as to where the burden lies with respect to the defense?
So I found a conflict in jurisdictions.
All right, so what's the 4th say? That's where we'll start with the 4th.
Governor, can I just read something from the...
Well, I don't want to cut Mr. Wahid out, and then I'll come back to you, Ms. Black.
So my understanding is that Radford, which comes out of the 4th and becomes a Supreme Court case, is the one that I have found out of the 4th, which, in my view, it basically allowed, it didn't really specify who had the burden, from my reading of it. And I don't know.
Do we know what instruction was approved in that case? What ultimately they affirmed or overruled as far as what should have been read?
So there was a mistake in the reading of the jury instructions in that case, so it gets messy to get into that. But subsequent to that case is this amended instruction that we now have in front of us.
So the amended instruction, which gives me no clarity, is a result of the lack of clarity from the Radford or Radford decision?
R-A-D-F-O-R-D.
All right, the Radford decision. And there have been no other, what about any other DCAs that have addressed the issue?
Well, to be honest with you, I went with the Supreme Court. That was the last Supreme Court case.
But it gives me no guidance. If it's telling me, if it doesn't pick one or the other, then I don't know that it helps me.
So my take, Judge, is that it used to be an immunity issue. It's now an affirmative defense. So I would take it as other affirmative defenses, such as self-defense, where the burden of raising it is on the defense, and then the burden of persuasion is on the state. So in my position, I think that's a fair read, considering it at one point in time was you had the immunity of it back in the day as a parental defense.
All right, so Ms. Black, you wanted to add something or read something?
Pursuant to the jury instructions, it states that Florida Statute 827.03 and case law are silent as to 1, which party bears the burden of persuasion of the affirmative defense, and 2, the standard for the burden of persuasion. Under common law, defendants had both the burden of production and the burden of persuasion on affirmative defenses by a preponderance of the evidence. The Florida Supreme Court has often decided, however, that once a defendant meets the burden of production on an affirmative defense, the burden of persuasion is on the state to disprove the affirmative defense beyond a reasonable doubt, so such as the self-defense or the consent to enter into...
Isn't that kind of what Mr. Wahid is saying?
Yes.
So where's the dispute then? If you're reading that and that's what Mr. Wahid is saying, then it sounds like the burden of raising it starts with the defense, but once they've met a threshold, then the burden shifts to the state to disprove. And the question is, the burden that shifts to the state to disprove, what standard is that? Is that beyond a reasonable doubt, or is that preponderance?
From the reading, it would, if the burden of persuasion is then on the state to disprove that affirmative defense, it would be beyond a reasonable doubt.
Okay.
I agree with that. It's like self-defense.
So it sounds like we don't really have an issue then. Do we, Ms. Black? And that is one of the options that is spelled out in the model standard instruction, that what you just described is the way it works. Let me see, read that part that fits what you just said is your understanding of the law. And so tell me again what I'd be reading to the jury with respect to the burden, the part of that instruction. I think it's the second part you were reading.
For if it's on the state?
Yeah, if it's on the state, because I kind of hear you saying that you don't disagree with that belief.
I don't disagree. It's just that the defense has not put on that burden of production of the affirmative defense.
And that's what I asked earlier. Is that something that I make a decision on and it never even gets to the jury to decide? Or does the jury have to decide that the defense has met the burden of, by preponderance of the evidence, of coming forth with enough evidence? And then if they believe that, now the state has the burden of disproving that by evidence beyond and to the exclusion of reasonable doubt. That's the question that I have for you to address.
Your Honor, I don't have an answer to that just because it says that the case law
Okay.
is silent as to.
Do this. Let me read the instruction right now. And do you have the Radford decision with you?
I do have a copy.
Okay, so is that the only significant issue?
Yes.
All right, so come armed tomorrow with two versions of that instruction, one with the version where the burden shifts to the state after the threshold is met by the defense, and the other one where it follows the common law. And I will read the Radford decision, read the instruction that you're going to give to me in just a moment, and then I'll make a decision at the beginning tomorrow as to whether I need additional argument or whether I'm going to rule as to which ones to be read.
And I think one moment, Judge.
Your Honor, may I approach?
You may.
And so we're also asking for the lesser, which is jury instruction 16.3.
Just regular child. There's no real issue with the lesser, is there?
No, I already added that into it. It's just
Well, lesser is the lesser to aggravated child abuse. The lesser is child abuse. What about any lessers to false imprisonment or child neglect? No lessers to those? So I don't think there's an issue there. So I would be inclined to go ahead and agree that the lesser should be read in relation to the primary charge of aggravated child abuse. So that should.
I'm sorry to interrupt,
Go ahead.
Your Honor, but what I did is with the jury instructions, I did the aggravated child abuse, the false imprisonment, and then the neglect. And then right after that, I did the 3.4 when there are lesser.
Yeah, that's the way I typically do it. Yeah. You read all the primary charges, then you get into the lessers. That's the way I typically have them. Now you've done jury trials in front of me. Just make sure that the order of the instructions are in the order that I require them. I think they were very close the last time I looked at. So I'm not able to answer the one question that I know grips all of you at this point as to which instruction will be read on the issue of the defense, but I'll make that ruling, as I said, at the beginning of tomorrow when we start. But come with, one page. It's a one-page instruction, right? Yeah. One of each, so that we can slip them in to the packages, and then we'll go from there.
And then for weighing the evidence, we have 6 through 10. Number 6 is, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness testified? I think we can include that just because.
Well, it should be because of the expert testimony.
Then we have, had any pressure or threat been used against the witness that affected the truth of the witness's testimony?
I don't think so.
I don't really care one way or the other about that. I mean, I did not hear any real evidence of that, but yeah, so that can come out. If it comes out by agreement, I'm fine with it. Nothing for me to rule on.
Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court?
I think that stays in based on the evidence.
And then I think the last two can come out. Has the witness been convicted of a felony, misdemeanor involving dishonesty or false statement?
That's not an issue in any part that I'm aware of. Do you agree with that, Ms. Wade?
I agree with that.
Does the witness have a general reputation for dishonesty, truthfulness?
I don't think there was reputation evidence here.
No.
Okay, so that comes out. So the only other aspect is going to be the part of the instruction that deals with defendant testifying or not. So you'll need two versions of that. So two versions of the defense instruction and two versions of the defendant testifying or not testifying. Just have those set aside so we can slip them in where they go. All right, anything else that I need? Go ahead, Mr. White.
I know that you asked the state and you didn't ask me, but I'm just going to opine anyways that I do think that the defense is like self-defense, which means you just once the defendant raises it, even and under certain case law, the wording is a scintilla of evidence. That is then the instruction can be read.
Yeah, maybe I assumed your position was it has to go to the jury, that I don't make the decision to take it away from them.
100%.
Yeah, I assumed that was your decision. That's why I didn't ask you expressly, because I presume that was where you're going with it. Okay, so before we conclude for today, let's address. I think we talked Friday about the closings being anticipated to be an hour and a half per side. Does that still hold? Yes. All right. And so for the state, how are you going to allocate your time between closing and rebuttal?
An hour and 15 for the first closing.
All right, with 5-minute warning or 10-minute? 5-minute warning on each one, and then okay. And then how about the defense? Just a 5-minute warning?
I might ask for 15 and a 5.
It's fine. If you just tell me what you want, I'll give you whatever you need. 15 and 5, is that?
Can I get 30 and 5?
You can get whatever you want on that. 30.
Okay, low pressure. Okay.
All right, 30 and 5 will be fine. All right, so that, Danny, you have all that?
Yes, sure.
All right, so I don't know. We'll start at 1. It's going to get us to 4. We'll have a conversation after the closings with breaks and stuff. We are going to be very close. We might as well address it now. We're going to be very close to 5 o'clock tomorrow, starting at 4, starting at 1 with 3 hours of closing and with breaks in there. Whether we, after closings, recess until the next day so that they have the entire day as opposed to send them in the room at close to 5 o'clock. I'm generally hesitant to do that because I never want a jury to feel rushed in terms of their verdict. Let me hear thoughts from both sides on this, because it's going to come up tomorrow, no doubt in my mind. Because my suspicions are that we'll get very, very close to 5 o'clock before we're done with closings.
Well, the state's position is, I think if you allow them to go back there, it allows you to release the alternates. They can do a 4-person. Otherwise, you kind of technically, I think, have to bring the alternates back.
Well, but that's the concern I have, is that I won't release the alternates till I send them back there. If I release the alternates tomorrow, and then we have a problem, then we have a problem. So my feelings would be not to release the alternates until I know that they're going to go in and have time to deliberate. But we do it. I mean, there's a risk. I mean, the 6 that are the primary jurors, they've been here the whole time, so I don't anticipate any problems. But you want to have another conversation on this tomorrow, late in the day?
Just to be clear, I think from our position would be on the defense that we just bring them all back on Thursday morning and let them start fresh. These are long days. I agree. I don't want the jury rushed. I don't want them feeling exhausted and having to hurry to a decision. And if the downside is the alternates have to come back the next morning, I think that's just part of the job.
Well, I mean, for the alternates, it's not going to be good news no matter how you cut it. They will have sat through 7-8 days of trial, and then they're going to be excused. Maybe they will be happy to be excused. Sometimes they are. Other times I can see the disappointment in their eyes. Let's have a conversation about this tomorrow, later in the day. I mean, my druthers, Mr. Waheed, are to do what you're suggesting and have them start fresh on Thursday rather than dropping it on them late on Wednesday afternoon. But if we finish early, if the closings only take an hour or hour and 15 minutes, then we'll go to Plan B in that event. Then we have time to put them in the jury room for an hour to talk about things.
Fair. We're going to work on jury instructions at noon, correct?
Yeah, well, I'm hoping that you come in with a very close to final set. I will tell you what my ruling is after I review this information in terms of the defense. So I don't expect a lot of argument that's going to be required. But I'm giving us an hour if there's anything to get. Once I rule, it gives you time to administratively get the packages together, gear up for your closing arguments, and then we'll go from there. And then also to do the colloquy, because you're going to advise me as to whether he's going to testify outside the presence of the jury, and then I'll do the colloquy. All right, good enough, everybody? Anything else? All right, court is in recess, and I'll see everybody tomorrow at noontime.
Court is in recess.